To go see your boyfriend.
Yeah, he's got a nice room. You won't have it long. He left a call for 7 a.m.
Why don't you go see your boyfriend?
Yeah, he's got a nice room. You won't have it long. He left a call for 7 a.m.
See if we can figure out something.
Listen to your phone.
Hi, friends. Sorry about the double intro. I accidentally hit the same thing twice. Oops. I'm here and with Tooth. Went this morning and, well, midday, and the dentist basically said, he's not a dentist, he's a maxillofacialist. He took out all 4 of my wisdoms and did a phenomenal job. And he said that he can do like a 3D implant thing of sorts. It's not as urgent as I thought. I can go to his friend, like, to get it filled for a little bit. So I feel much better now. Lisa was here first at 4 minutes to 3 for me, by the way, which is like 20 minutes early. Little Miss, I just saw it pop up. However, I cannot do anything with it right now because I don't want to lose the things that I have open. And I currently have Judge Simpson has a landlord-tenant today that I have part 1 and part 2 already edited, that I'm just waiting for part 3 today, which is a trial, before I can post it. So I've got that recording, and then I set up, oh, okay, that's very dark. I'll have to fix that when we get started. But I set up the cat cam. There's 2 cats there. You just can't see them. On the other laptop, so that's streaming. So I can't have a million tabs open like I normally do. I'm also busy downloading Judge Middleton because there's a hearing that this is now the 2nd one, I think, that happened yesterday. That was really intense. So my internet is doing a lot of work. And I also wanted to mention that in case there's a bit of a lag or something, you know why. I can solve it. I just need to pay attention to it. Right, let's go down the list. Hi, Lisa. Hi, Little Miss. Hi, Sheena. Hi, Braxton. Hey, Steve. Hey, Trish. Yes, Trish. Hey, Sim. Hey, Jamie L. You stole me from Judge Simpson's stream. Well, I can help you out and tell you that it has not started. And I am also a little concerned because it says the only person in the chat at the moment is Brittany Berkey. And we are not waiting for a Brittany Berkey. We are waiting for, what is his name? I can't even open I don't want to open the downloaded thing, the edit, because it's in iMovie. It's literally ready to go once I just add today's. But it's a guy who got kicked out. I showed it I want to say a month ago, the first part. And then the other part, I was watching Stabbed in the Heart when it happened. So I saved it. And then at the end of that, they said they'll be there today. So this is currently what I'm working off. I know it's weird and I could have it in a calendar, but today I've got Panic Attack Tenant. I have to show you guys that once she's been there today, and Locked Out. And then I also have Alan, ? Jerome, ? Landlord Tenant Final Settlement. So today's Simpson is like the most important one for me. And then the other thing I wanted to mention is there is a trial coming up called Jim Craig. He is a dentist who allegedly poisoned his wife. Feels kind of close to home, given I've been at the dentist more times this week than normal. Let's see if we can find anything about him. Jim Craig. So Jerome, the Jerome one is the one with the Karen lawyer, who's not a lawyer, who's now a witness. And Alan, we were also following, but I've forgotten now. What was I going to look for? I was going to look for Jim Craig. Colorado dentist allegedly poisoned wife's protein shake to leave her for orthodontist. So I'm waiting to see if there's anything happening there that's online. I am not entirely sure if I want to do live again because of time zones. Where is this though? Aura. Is there only one Aura? Colorado. Okay, US friends, help me. What time zone am I looking at for Colorado? I've got New York, Central, Texas, Michigan, and Olympia. Mountain. I don't think my thing has mountain. Let's see if it has Denver. So it's 2 hours, 1 hour behind Central Time. So if they start, they would be starting about an hour and a half from now. That would take me to 1 hour would be 4:30. So it would take me to 5 p.m. 6, 7, 8, 9, 10, 11, 12, 1 a.m. So if they're doing full days, we may have to do like catch-up sessions or something. Okay, first things first. Sarah Boone, because I'd say about 4, I'd like to get back into focusing. She wrote a 29-page long letter. And I don't know if you guys want to hear. Let's do this. I've started a poll. We also have a bunch of new people. So I just want to say from my perspective, oh, sorry, I'm kicking things. Sarah Boone, to me, has had probably one of the best examples of trial by media. And I don't like that vibe at all. She has done things that have not made her situation better, but I would prefer to look at it from a more objective stance and say she is still innocent under the law? And also, how would, if we just look at the facts, how would a, let's say, reasonable person respond to everything that's gone on? And for me, I feel a bit like I don't want to pile on. My on-air sign is not on. I don't want to pile on. I don't want to be nasty. We don't know all the ins and outs. She's still innocent. I'm not just going to presume that she is crazy or that this has happened or that has happened. I'm just going to look at it factually speaking. And from a journalist perspective, essentially what I'd do is I'd look at 5 whiskeys in the hotel. So who, what, why, where, when, and how. And the why needs to be a 2 sides thing, right? So you can have why because she's maybe twisted and planned it, or it may be years of enduring certain things. And that's what led us to this day. The reason I am hesitant to just say that she is a bad person is because I actually did a video on the 911 call all those years back. And what really stuck out to me when I watched that suitcase video over and over, by the way, because I had to get the right timestamps and all of that, is she says, now you know how it feels when you strangle me. And that for me is like a ping ping moment because statistically speaking, people who strangle their partner in a power sort of situation, I'm not talking in the bedroom, you do what you want there, but in a non-bedroom situation are more likely to kill them. That's statistically speaking. So from what I'm looking at, I need to be understanding of both sides. I suspect I know why she's gone through all these lawyers, but I don't know for sure. I really wish we could find out. I think that I would probably be as frustrated if I felt I knew my side and I felt my story wasn't being heard. Like for me, one of the easiest ways to frustrate me, oh, there's a little bug, is to make me feel unheard. I hate that. So no strong preference. Well, there's 56% for read the letter, then hearing, and 44% for skip the letter and just hearing. So if you do have a preference, now's the time to vote. She has a version of events that only she understands. Did you see that bug just flew past the camera? It's wants my plants. It wants to eat the nutrients of my plants, and I don't want it to. I don't know if only she understands. I don't know. Because she undoubtedly had a drinking problem. So from that perspective, I get that. They both had abuse claims against each other. So then I'm kind of like, okay, was hers reactive or was it not? I don't know. Mixture of a few disorders. So, Tom, I think I brought this up the last time. This whole like ethical reasons thing. I don't know if have we heard the lawyers say that it's ethical reasons? Because like I said, I feel like this is just journalistically speaking, this is very much a trial by media sort of case. She's already guilty because she's been made to look guilty. she garners a lot of headlines, she gets a lot of attention. So it's very easy to create a pile-on and to maintain that perspective because she doesn't stop talking. So if I want to have the most clicks on my article or whatever the case may be, you put her name and she's going to pipe up again, and then that makes more, and that makes more, and that makes more, right? Like, she's a never-ending stream of content. Trish, I'm so sorry. This is not the way for a person to live at all. At all. And I think, like, this is when she said, oh, I just got goosebumps, like, literally feeling like, when she says something like that, my alarm bells go instantly, because one of his charges did have those kinds of allegations. She treats it like a game up till this point. I hear you. She's adamant she will go free, in my opinion. No attorney will present her case in the way she wants. They know she's guilty and their job is to get her a lighter sentence, not to free her altogether. I do believe at least one said they couldn't go forward with her because of ethical reasons and a motion to recuse. Yeah, which they can't do. That's kind of what I was understanding. She wants me to do things that I can't do. Like, I need to know more about that. What is it? I was pretty sure that the last, I cannot stop watching this bug fly around. I was pretty sure that the last attorney was going to get it. Now it's going to go in front of the camera. But I don't know what happened there. Yeah, her videoing it, that was a very, very, very silly thing to do. Oh, we're a hung jury on what to do now. Read the letter or skip the letter. The fact that she videoed it was not smart at all. She was incredibly drunk. And then the flip side of that, and I know some people are going to be going absolutely crazy with me constantly doing devil's advocate, but this is just like, this is what I have to do in my everyday life to be good at my job. I have to, like, consider the absolute devil's advocate side of it to be able to cover all bases and bring it all back. The other side is, if you don't have evidence of abuse, it's often not believed. So, I mean, like, Ashley Benefield brought out some perspectives that people hadn't thought about. As an example, oh, but she never had bruises. Oh, he was never physical. Okay, but sometimes people don't have bruises and sometimes it isn't physical. Mika Miller is an example. Sometimes there's a lot going on and the alleged perpetrator gets around it in other ways. So was she filming because he had said something and she knew what was coming? I don't know. She said they were joking around. I don't know. Does anyone know if she was offered a deal? I don't think she was. Okay, we're still on 50-50. So given the time, please just let me keep. I don't know if I got it. Sorry, I hope that wasn't like super loud. Devil's advocate is the best way to approach jury duty. Yeah. It's also the way that you're supposed to approach everything you put out as a journalist, but different countries have different things. I would hope and wish that every journalist would approach things like that, but I've come to realize that it's not the case, and it frustrates me to no end. Okay, so since we are We're still at 50-50. Sometimes there isn't physical evidence to real, but sometimes it's, but also sometimes people lie. Yes, 100%. 100%. And I am always wary of, like, the worst thing for, let's just take an example. And I don't want to get heated. It's just the best example I can think of. The Me Too movement. Most women have those stories. As soon as, especially in South Africa, I don't know about the US, but in South Africa especially, most women have those stories. As soon as someone says something happened and it didn't, immediately that takes the whole cause with it. So lying about this kind of thing is, I would, in that situation, I would probably want some sort of charges, because, and it would have to have been proven that didn't happen, right? Like, I'm not just saying just because there's no proof that it did happen or didn't happen that it should go a certain way. But I think it's absolutely despicable, because it just, it's bigger than just you telling a friend or telling a small lie. Benefield trial was a mess. That was another jury that was hung and rushed into settlements on a lesser included charge. Garbage. In my opinion, they acted on emotion and not the law. I think all juries do, but I know that many people are not going to be happy with that. Okay, let's watch this hearing. And I also want to say, if you disagree with me, that's absolutely okay. I don't mind. I like people giving their side. I want to hear it. Like I said, I want all the devil advocate ideas that are possible, because that's how I essentially get to my understanding. I need to hear everything before I can have my own well-rounded opinion. Oh, Psychosaurus. So, sorry, I want to go to that one. This is wild, because essentially, when I was more actively involved in the media space, I was part of traffic groups. Like when there's an accident and then the media sends out the picture, but it's been like blurred and, it's cleaned up so that it's not as traumatic. I'm still in those. And on Friday, we saw an accident and we're nearly pulled into it with a drunk biker. And I have all sorts of trauma with that. Anyway, that's for my psychologist to hear, not you guys. Sorry. I don't want to drag anything into it. But basically, what we spoke about is that because our brains struggle to know what's real and what's not, seeing those pictures after a traumatic thing like that, my brain's thinking that that's like, it's in my world. It becomes part of my memory. It's like, it's also why I tried to do a self-defense thing where you actually like play it out, and I couldn't do it because it was way too real. Right, let's go. Okay, so now we're on 54%, read the letter. Let's do this. We'll watch a bit. I'm not sure about this. I'm not sure. I don't know how intertwined they were. I'm just getting fed up with juries acting on emotion and lesser included charges shouldn't be a thing. Apple River trial being my example of that. In fact, speaking of my brain seeing things and it becoming a memory, that Apple River trial hearing, I mean, that video of the kids, because of the perspective it was shot at, I kept dreaming about it and my brain kept trying to process it. it felt so real to me, and I seldom have that happen when I'm just like observing a news story or writing about it. Okay, let's watch a bit of this while I sort out the cat cam, and then we can see what the verdict is on the.
Case number 2020 CF2603, the state of Florida versus Sarah Boone, state.
Cat Strong, on behalf of the state. William Baker, the state.
Ms. Boone, raise your right hand to be sworn, please. Do you swear the affirm the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God? Yes.
Ma'am, good morning. Could you please state your full name and date of birth for the record for me?
Sarah Boone, 1077.
I do see that we have a representative from JACS that's appearing virtually. Sir, can I get your appearance for the record as well?
Yes, Your Honor. Christian Lake with the Justice Administrative Commission.
Okay, very good. All right, we've got a couple of things that we're going to be addressing this morning. The first is the motions, Ms. Boone, that you had made reference the last time I saw you. The court has reviewed all of those motions. I've reviewed also JACS's reply, specifically their response to the motion seeking due process costs that was filed on July 30, 2024. State, have you had the opportunity to review all of Ms. Boone's motions?
Yes, Your Honor.
Okay, all right. Ma'am, I want to go through each one of them and hear from the state, from yourself, and from JACS. We're going to start first with the, y'all can be seated, you don't need to stand, thank you. The defendant's temporary motion for reservation of proposed costs to acquire investigator for defendant's defense and trial dated July 18, 2024, received July 29th. That request seeks to reserve any and all costs proposed to be incurred to acquire investigator. The defendant's temporary motion for reservation of proposed costs to acquire all witnesses for defendant's defense and trial dated July 18, 24, received July 29th, 2024. The request is to reserve any and all costs proposed to be incurred to acquire all witnesses for trial. And then defendant's temporary motion for depositions to be conducted per FRCP Rule 3.220 by defendant under pro se attorney title and position ordered by the judge in court dated July 18th, 2024 and received July 29, 2024. I have reviewed all of those motions. All three motions reflect to be determined or TBD with regard to the investigator, witnesses, and deponents. The total amounts are to be determined. How to calculate is unknown. As for the depositions, the date are to be determined and the amount of transcripts are unknown. Mr. Lake, I've reviewed your response. Do you have anything else to add, sir, with regard to those items, investigators, witnesses, or deponents?
Not really, Your Honor. The only thing is if we can provide Ms. Boone a copy of our pro se packet that has information about including model motions. We would be happy to send her a copy or to send your JA a copy that you could send to give to her. That might help her for purposes of future motions. But as far as these are concerned, I think our response pretty much outlines what our position was to each of those requests.
Okay, thank you, sir. If you would be so kind to send that to Ms. Barrios, we will ensure that Ms. Boone gets a copy of it. State, do you have any position with regard to those three motions that the court just identified?
No, Your Honor.
Okay. All right, ma'am. So previously, Prison Break Investigations was already appointed to be your investigator. The JAC has no objection to authorizing $5,000 in costs for Prison Break and for $500 for obtaining case-related documents and materials on your behalf. So seeing as there's no objection, even though you were asking for a reservation, I'm going to go ahead and permit that cost to be incurred. With regard to the costs for witnesses and
All right, before they go into that, that's a good time for me to jump over to the letter because it won. Let's see. Okie dokie. The tip of the tongue, the teeth, the lips, the tip of the tongue, the teeth, the lips, the tip of the tongue, the teeth, the lips. Motion requesting immediate relief to the defendant by appointing effective standby counsel to aid and support in preparation of her criminal case for trial. Comes now, Sarah Boone, pro se indigent defendant, respectfully requests from the court immediate relief by providing effective standby counsel with all legal services allowed and included to assist and aid the defendant as a whole in the complex, vital procedural preparation with professional guidance during her forfeited right to counsel by the court as pro se attorney, and in her proposed lawful representation of self in her criminal case. Is my mic level okay? Before I carry on. There's such a delay. It's always so awkward. Just waiting for the answer. Not using the tour guide Barbie voice. Phew, it'll be a long hearing if I use tour guide Barbie voice. I can do news voice though. Just haven't done it in a while. Oh, let's see. Problem is also for news voice, I have to stand. Defendant's justified reasons for requested relief and assistance are as follows. 1. The defendant's sixth constitutional right to counsel is being violated, unlawfully withheld, and forcibly removed from the indigent defendant under false pretenses, speculation, libel, and misconstruction. By the defendant's lawful practice of her entitled first constitutional rights to free speech and her God-given right to do so by writing her experience-derived truth and providing red flag exposure in her correspondence to the court, requesting needed intervention to avoid present circumstances, she has lost completely her ability and advantage to properly, rightfully, successfully prepare her defense of innocence, progressively advance fairly and unrestricted, while having the ability to be leveled equally with the prosecution. I need to sit. It's very difficult to scroll. Right. 2. The defendant is not an officer of this court or any court or legal system as a whole. She is not bound lawfully under oath or certified in any professional means to be or act as a legal agent or representative, lacking requisite professional competency, experience, expertise in the field of law presently and historically. The defendant is defective and ineffective counsel to self as a result, which therefore will detrimentally impact and impede favorable justice to the defendant and the opportunity of a fair trial based on equality with an unprejudiced conclusion of her case. The defendant is presently incarcerated, which is causing and will cause unfair burdens, limitations, deprivations, inaccessibilities, and unequal opportunities in and to her ability to complete tasks timely and responsibilities suitable to the vital defense of the defendant's life and livelihood futuristically. By the court rejecting professional, educated, experienced aid and assistance of effective standby counsel to and for the defendant in preparation and production of her rightful defense, results may be adverse from the unfair, disadvantaged, oppressed circumstances to properly thrive in her forced position by the court of pro se attorney and representation of self. Next. Examples of said unfair burdens, limitations, deprivations, inaccessibilities, and unequal opportunities include: A. The defendant has not received from the court to date of this motion any of her promised discovery or case-related materials submitted by a former attorney to the court during the unannounced hearing on 6th of the 8th, 24. That's important. They promised they'd send it to her. That's important. How should she continue? With only 4 days to submit my demands and motions delegated by the court on or before 7/22/24. B. The defendant has not reviewed from the court to date of this motion any of her promised discovery or case-related materials submitted by a former attorney to the court during the unannounced hearing on 6/28/24. I just want to say, if I get stuck with numbers, it's not because I'm doing a listen properly. It's because we write dates 22/7/24. C. The defendant does not have access to a computer. They said they'd send one, though. D. The defendant does not have access to the internet. They also promised her they'd have that. E. The defendant has extremely limited, irregular access to basic tablets supplied by QCCD. F. Defendant has access to payphones for collect calls only, limited to 15 minutes each call. G. Defendant does not have access to organizational supplies or production equipment, copier, printer, etc. H. Defendant does not have access to a meeting place for privacy in case review, preparation. I. Additional daily obstructions and undetermined hardships, disadvantages, difficulties will likely come about due to being incarcerated, and once my case materials are finally received. Continued application in reasoning and further lawful support of defendant's requests for immediate relief with standby counsel to aid and assist in preparation of her criminal case. Is that an A? A. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. Amendment 11, forgotten my Roman numerals. B. Right to counsel is assured by the 6th Amendment, which has been incorporated into the Due Process Clause of the 14th Amendment, as well as state constitutions, so that every criminal defendant who faces a potential loss of liberty has access to an attorney who provides effective assistance of counsel at each stage of the criminal proceedings and process. Right to counsel applies whether the defendant can afford to hire a lawyer or not, in which case the court will appoint without charge to the defendant. Waiver of counsel is a criminal defendant's refusal of counsel at any stage in the criminal process. I have never refused. It is made by a person with full capacity, unprepared, that is knowing and voluntarily forced, in capital letters, and that clearly and unequivocally rejects representation or assistance by an attorney at law during the pending proceedings. A defendant's decision to waive their right to counsel must not only be competent, but also knowing and voluntary. The right to waive counsel, in brackets forced by the court, is the right knowingly to proceed in ignorance. It is sufficient for purposes of both the state and federal constitutions that the record, taken in its entirety, shows that the defendant comprehends that a waiver of counsel means that they will proceed into the labyrinth of the law without the assistance of a trained guide. Let's also remember that she's reached this point and nobody has done a psych evaluation that we know of. The court must first make inquiry into his competence and be reasonably satisfied of it before accepting the accused waiver of counsel. Never gave. Random aside, the way that it's spelled, INQ, inquiry, is different to an inquiry, technically speaking, in like news world, because an inquiry is I just forgot all the words. It's like a formal looking into. An inquiry is just like more informal. Competence means more than a minimum of mental awareness and capability, however, and involves an intelligent conception of the consequences of his act. No one explained to me. She just called herself incompetent for trial. Have they done a competency evaluation? The trial was a farce or a mockery of justice, or was shocking to the conscience of the reviewing court, or the purported representation was only perfunctory, in bad faith, a sham, a pretense, or without adequate opportunity for conference and preparation. D. Ineffective counsel is both a standard of inadequate performance for a lawyer in a criminal representation and a failure of due process of law to the criminal defendant. A person who has suffered a punishment in a criminal proceeding, I was repeatedly lied about by former attorneys to the judge, who is unjustly believing all over me, falsely accused me of an inappropriate and wrong strategy of removing attorneys who withdraw from my request for the court for intervention, causing me to be forced into losing my right to counsel from their ineffective counsel, to which there is a right to counsel, but who received ineffective assistance is ordinarily entitled to a new proceeding with adequate representation, as long as there is a reasonable probability that the result might have been different if the person had received adequate legal assistance. Due to ineffective assistance of counsel, the federal courts in 1999 set this second sentencing aside. E. Let me pause, see if there's any things that I missed. Good penmanship. Florida Constitution 2024 edition, Article 1, Declaration of Rights. Section 2, Basic Rights. All natural persons, female and male alike, are equal before the law and have inalienable rights, among which are the right to enjoy and defend life and liberty, to pursue happiness. Section 4. Okay, so this freedom of speech and the press, freedom of press, we actually watched a court hearing in the Oscar Pistorius trial. I labeled it to say media puts forward their argument on they didn't want to show autopsy pictures and that sort of thing. And so the court had to go through the hearing to see if it was breaking our freedom of press to not have those details in. Section 4, freedom of speech and press. Every person may speak, write, and publish sentiments on all subjects, but shall be responsible for the abuse of that right. No law shall be passed to restrain or abridge the liberty of speech or of the press. In all criminal prosecutions and civil actions for defamation, the truth may be given in evidence. If the matter charged as defamatory is true and was published with good motives, the defendant writing truthful, lawful letters to the court requesting help with dysfunctions of attorneys, then the defendant is unlawfully forced to forfeit her right to counsel from lies, misinterpretations, and ineffectiveness from those former attorneys, retaliation from the court. The party defendant shall be exonerated, given appointed counsel. So she's not meaning exonerated as in get out of jail free card, as in they will give her counsel. Section 5, right to assemble. The people shall have the right peacefully to assemble without harm, to instruct their representatives, and to petition for redress of any grievances. Section 9, due process. No person shall be deprived of life, liberty, or property without due process of law, or be twice put in jeopardy for the same offense, or be compelled in any criminal matter to be a witness against oneself. Section 16, rights of accused. A, in all criminal prosecutions, the accused shall, upon demand, be informed of the nature and cause of the accusation, and shall be furnished a copy of the charges, and shall have the right to compulsory process for witnesses, to confront at trial adverse witnesses, to be heard in person by counsel or both, and to have a speedy and public trial by impartial jury in the county where the crime was committed. Okay, sorry, I had a scratch. Section 21, access to courts. The courts shall be open to every person for redress of any injury, and justice shall be administered without sale, denial, or delay. F. The 14th Amendment to the Federal Constitution declares all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any persons of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. This provision has often been construed by the United States Supreme Court, and it has been uniformly held that due process of law requires ample notice to the accused and sufficient time to secure counsel and prepare for trial. A like rule as to necessity for due process and reasonable opportunity to prepare for a defense is declared in Franklin v. State of South Carolina, blah, 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 blah. With such notice, no, reading words that aren't there. Such notice was not a reasonable one, was not due process of law within the 14th Amendment to the Constitution of the United States, and a judgment obtained upon such notice was not binding upon the defendant. This law states that the essential elements of due process of law are notice and an opportunity to be heard and to defend in an orderly proceeding adapted to the nature of the case. The term due process of law, when applied to judicial proceedings, means a court of legal proceedings according to these rules and principles which have been established by our jurisprudence for the protection and enforcement of private rights. The accused cannot be deprived of his life, liberty, or property unless by the judgment of his peers or the law of the land. The law of the land, like due process of law, requires timely notice and an opportunity to defend. It is vain to give the accused a day in court with no opportunity to prepare for it, or to guarantee him counsel without giving the latter any opportunity to acquaint himself with the facts of the law of the case. Every man is presumed innocent and, when accused, entitled to a reasonable opportunity to prepare his defense. Okay. It is true that great and inexcusable delay in the enforcement of our criminal laws is one of the grave evils of our time. The prompt disposition of criminal cases is to be commended and encouraged, but in reaching that result, a defendant charged with a serious crime must not be stripped of his rights to have sufficient time to advise with counsel and prepare his defense. To do this is not to proceed promptly in the claim spirit of regulated justice, but to go forward with the haste of the mob. Lil Miss, the thing is that if she was a lawyer, she'd have to give all the case law and have to argue the case law. So her giving it is actually, it's actually a positive move. Like, in a way, she's kind of shooting herself in the foot because she's showing that she can understand case law. An affirmation of the right to the aid of counsel in petty offences and its denial in the case of crimes of the gravest character where such aid is needed most is so outrageous and so obviously a perversion of all sense of proportion. Recognizing that the rule was settled at common law, denounced as not in keeping with the rest of the humane treatment of prisoners. For upon what face of reason can that assistance be denied to save the life of a man which yet is allowed him in prosecutions for every petty trespass? How can a judge whose functions are purely judicial effectively discharge the obligations of counsel for the accused? He can and should see to it that in the proceedings before the court, the accused shall be dealt with justly and fairly. He cannot investigate the facts, advise and direct the defense, or participate in those necessary conferences between counsel and accused, which sometimes partake of the inviolable character of the confessional. Article 5 declared that all criminals shall have the same privileges of witnesses and counsel as their prosecutors. Every person charged with treason, murder, felony, or other capital offense should be admitted to make full defense by counsel learned in law. This is a long thing. We're on page 15 of 29. Notice and hearing are preliminary steps essential to the passing of an enforceable judgment, and that they, together with the legally competent tribunal having jurisdiction of the case, constitute basic elements of the constitutional requirements of due process law. The words of Webster, so often quoted, that by the law of the land is intended a law which hears before it condemns. Remember what I said at the beginning. You need to hear. She can't be guilty yet. She hasn't been heard. Judgment without such citation and opportunity wants all the attributes of a judicial determination. It is judicial usurpation and oppression, and never can be upheld where justice is justly administered. Even the intelligent and educated layman has small and sometimes no skill in the science of law. He is unfamiliar with the rules of evidence. Left without the aid of counsel, he may be put on trial and convicted upon incompetent evidence or evidence irrelevant to the issue or otherwise inadmissible. He lacks both the skill and knowledge adequately to prepare his defense, even though he have a perfect one. Probably he may have. He requires the guiding hand of counsel at every step in the proceedings against him. Without it, though he may not be guilty, he faces the danger of conviction because he does not know how to establish his innocence. If that be true of men of intelligence, how much more true is that of the ignorant? If in any case, civil or criminal, a state or federal court were arbitrarily to refuse to hear a party by counsel, it reasonably may not be doubted that such a refusal would be a denial of a hearing, competency, and therefore of due process in the constitutional sense. The decisions all point to that conclusion. Pointing to the fact that the right to counsel as secured by the Sixth Amendment relates only to criminal prosecutions, Judge said, but it is equally true that the provision was inserted in the Constitution because the assistance of counsel was recognized as essential to any fair trial of a case against a prisoner. A case involving the due process clause of the 14th Amendment, the court said, by the way of illustration, that if the state should deprive a person of their benefit of counsel, it would not be due process of law. Judge Cooley refers to the right of a person accused of a crime to have counsel as perhaps his most important privilege. And after discussing the development of how the law upon that subject says, with us, it is a universal principle of constitutional law that the prisoner shall be allowed a defense by counsel. The necessity of counsel was so vital and imperative that the failure of the trial court to make an effective appointment of counsel was likewise a denial of due process within the meaning of the 14th Amendment. All that is necessary now to decide, and we do decide, where the defendant is unable to employ counsel and is incapable adequately of making his own defense because of ignorance, inexperience, or the like, it is the duty of the court, whether requested or not, to assign counsel for him as a necessary requisite of due process of law, and that duty is not discharged by an assignment at such a time or under such circumstances as a preclude the giving of effective aid in the preparation and trial of the case. To hold otherwise would be to ignore the fundamental postulate? Huh? Is that I can't read that one. Already adverted to, that there are certain immutable. She's obviously getting tired here. Her writing's starting to go skew. Which in the very idea of free government, which no member of the union may disregard. In a case such as this, whatever may be the rule in other cases, the right to have counsel appointed when necessary is a logical corollary from the constitutional right to be heard by counsel. Compare Carpenter and Sprague. In Hendricks v. State Supra, there was no statute authorizing the assignment of an attorney to accomplish the ends of public justice, and that the court possessed the inherent power to make it. Where a prisoner, the court said, without legal knowledge, is confined in jail, absent from his friends, without the aid of legal advice or the means of investigating the charge against him, it is impossible to conceive of a fair trial where he is compelled to conduct his cause in court without the aid of counsel. Such a trial is not far removed from an ex parte proceeding. Let us suppose the extreme case of a prisoner charged with a capital offense, unable to employ counsel, with the whole power of the state arrayed against him, prosecuted by counsel for the state without assignment of counsel for his defense, tried, convicted, and sentenced to death. Such a result, which, if carried into execution, would be little short of judicial. I cannot read that at all. Murder. It cannot be doubted would be a gross violation of the guarantee of due process of law, and we venture to think that no appellate court, state or federal, would hesitate to decide. And she has more references. The legislature has become so thoroughly convinced of the impropriety and injustice of shackling and restricting a prisoner, maybe without respect to his defense, that they have abolished all these odious laws, and every person, when he is accused of a crime, is entitled to every possible privilege in making his defense and manifesting his innocence by the instrumentality of counsel and the testimony of witnesses. In a long line of cases that include Powell, blah, 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 this court has recognized that the Sixth Amendment right to counsel exists and is needed in order to protect the fundamental rights to a fair trial. The Constitution guarantees a fair trial through the due process clauses, but it defines the basic elements of a fair trial largely through the several provisions of the Fifth Amendment, including the counsel clause. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state, and distinct wherein the crime shall have been committed. Okay, she's already done that one. A fair trial is one in which evidence subject to adversarial testing is presented to an impartial tribunal for resolution of issues defined in advance of the proceeding. The right to counsel plays a crucial role in the adversarial system embodied in the Sixth Amendment, since access to counsel's skill and knowledge is necessary to accord defendants the ample opportunity to meet the case of the prosecution to which they are entitled. Okay. 22 of 29. Because of the vital importance of counsel's assistance, this court has held that, with certain exceptions, a person accused of a federal or state crime has a right to have counsel appointed if retained counsel cannot be obtained. That a person who happens to be a lawyer is present at trial alongside the accused, however, is not enough to satisfy the constitutional command. The Sixth Amendment recognizes the right to assistance of counsel because it envisions counsels playing a role that is critical to the ability of the adversarial system to produce just results. An accused is entitled to be assisted by an attorney, whether retained or appointed, who plays the role necessary to ensure that the trial is fair. For that reason, the court has recognized that the right to counsel is the right to effective assistance of counsel. Federal Rules of Criminal Procedure. Right to an appointment of counsel. Right to appointed. A defendant who is unable to obtain counsel is entitled to have counsel appointed to represent the defendant at every stage of the proceeding, from initial appearance through appeal, unless the defendant waives this right. Defendant has been forced to forfeit her right to counsel from one-sided lies and unquestioned, misinterpreted requests for understanding, intervention for remedy, not removal from the defendant to the court in a criminal case. Appointment procedure. Federal law and local court rules govern the procedure for implementing the right to counsel. Notes on Advisory Committee on Rules 1944. This rule is a restatement of existing law in regard to the defendant's constitutional right of counsel as defined in recent judicial decisions. The Sixth Amendment provides, in all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense, which is derived from the Act of April 30, 1790. Every person who is indicted of treason or other capital crime shall be allowed to make his full defense by counsel learned in law, and the court before which he is tried or some judge thereof shall immediately, upon his request, assign to him such counsel, and they shall have free access to him at all reasonable hours. To the present extent of the right of counsel has been defined recently in Johnson v. Zerbst, The rule is a restatement of the principles enunciated in these decisions. When society acts to deprive one of its members of his life, liberty, or property, it takes its most awesome steps. No general respect for, nor adherence to, the law as a whole can well be expected without judicial recognition of the paramount need for prompt, eminently fair and sober criminal law procedures. The methods we employ in the enforcement of our criminal law have aptly been called the measures by which the quality of our civilization may be judged. United States Supreme Court. Okay. Wherefore, Sarah Boone, pro se indigent defendant, respectfully requests to the Honourable Court to provide immediate relief to defendant by appointing effective standby counsel to aid and support in preparation of her criminal case for trial. The defendant is requesting collaboration, correct understanding, and overall perspective of and in her extraordinary circumstances by rendering her cognitive incapabilities, procedural inabilities, and extremely limited capabilities altogether as fact, and concluding a remedy of assistance is rightfully needed to be provided to the defendant by the court. Appointment of vital standby counsel will lessen greatly her probabilities of further loss, damage, spoliation, looks like there's a Z there, and oppression in her criminal case. Fair and equal position by fair and equal opportunity will also be greatly enhanced. Just need to take a breather. The defendant's requests are in good faith, and her merits are worthy in striving to successfully, lawfully, and properly perform, act, thrive, and overcome her forced by the court position of pro se attorney and her representation of self. Conclusion. This motion for immediate relief to defendant by appointing effective standby counsel to aid and support in preparation of her case for trial should be granted. And then she signs under oath, certificate of justice, and the envelope. Okay. So, I also just want to mention, I don't want people to be nasty about her in the comments, because factually speaking, she is still innocent. And I don't want to create factual problems. Okay, let's watch the hearing, because I need to rest my voice for a little bit, and I need to focus and also go sort the cat camera.
The depositions, you are requesting, as I identified earlier, just to reserve those costs. And as I had said earlier, the motions do not identify who the witnesses are or what the deponents are. So I'm going to deny those motions with prejudice, but that means you can refile them and we can readdress them when you file motions in the future addressing any of those items for ensuring witnesses being subpoenaed or appearing for your defense at trial, or for any persons that you may seek to depose. Because as of right now, I don't know who it is that you were seeking to depose based on your own motions. Do you understand the court's ruling as to those three motions, and do you have any questions, or do you want to add anything?
I would like to add, please.
Sure.
With your delegated due date of July 22nd, for all of my pretrial motions to be submitted, I have yet to receive my discovery, so I was trying to beat that deadline or at least meet it. So I don't know what I'm supposed to ask for or who I'm supposed to ask for, and again, I have yet to receive my my discovery, so I don't even know who it is I need. So I understand for those, so you're telling me at a later date, once I have that information, to revise them?
I'm giving you the opportunity to refile them. Yes, ma'am.
Thank you.
With regard to the defendant's motion for reservation of proposed costs to hang on. With regard to defendant's motion for reservation of proposed costs to acquire expert witnesses for the defendant's defense in trial dated July 18th, 2024 and received July 29th, 2024. Mr. Lake, anything else to add other than what is identified in your response?
No, Your Honor, again, the issue here is, with the exception of the mental health expert that's already been approved, there would need to be much more specific motions for these costs. Ms. Boone needs to include essentially what we included in our response. And again, the model motions that we will be sending to will have that information. Without specific information, neither us nor the court can make an informed decision on whether the requests are appropriate.
Okay. Ma'am, the motion fails to identify any specifics. It has to be determined for your expert witness or witnesses. It does not identify the type of the witnesses. It doesn't identify the amounts, and it's difficult for me to identify the particular showing of need, which is what's required for the appointment of that expert. So again, I'm going to give you the opportunity to refile in the future a motion pertaining to any specific experts, identifying the specificity that JACS has requested in their response. So at this point in time, that motion is denied without prejudice, and you'll have the opportunity to refile it. Lastly is the defendant's motion requesting immediate relief to the defendant by appointing effective standby counsel to aid and support in preparation of a criminal case for trial dated July 18, 2024 and received July 29th, 2024. The request, ma'am, that you were seeking in that motion is to provide immediate relief to defendant by appointing effective standby counsel to aid and support in preparation of her criminal case for trial. State, do you have any position with regard to Ms. Boone's request for standby counsel?
No, Your Honor, other than what's already been placed on the record in the court's order.
Okay. Mr. Lake, anything over and above what's in your response?
Just briefly, Your Honor, the point we would make, Your Honor, is I think Ms. Boone misunderstands the role of standby counsel. Standby counsel is not co-counsel or assistant counsel to a defendant. Standby counsel is there for when, in the situation where a pro se defendant who is elected to represent herself decides at some point they want a lawyer, that allows the court to put a lawyer back into play at that point in time. In other words, it's a safety mechanism so that if a defendant who is decided to represent themselves decides at some point they do no longer want to represent themselves, the court has a lawyer already in place so that the progress is not delayed. It is not an assistant or a co-counsel. It is someone whose role is consenting not to get involved until the defendant says, I no longer want to represent myself.
Ma'am, the courts had the opportunity to review the case law on this issue. There is no constitutional right to standby counsel as decided by Paul versus State 152 Southern 3rd 635 at pinpoint 641 by the Florida 4th District Court of Appeal in 2014, citing to the Florida Supreme Court case in Jones v. State 449 Southern 2nd 253 at pinpoint 258 from 1984. As the court has determined that you have forfeited and alternatively waived by your conduct the right to court-appointed counsel, the court is not required to appoint standby counsel. That's Brown v. State 45 Southern 3rd 110 at pinpoint 114 through 115. Florida 1st DCA 2010, citing to, again, Jones v. State by the Florida Supreme Court in 1984. There is no Sixth Amendment right to simultaneously proceeding pro se and with legal representation by the Florida Supreme Court in 2009 in Shepherd v. State, 17 Southern 3rd 275 at 279. For the reasons that the court identified in its 16-page order previously entered, your request for standby counsel is denied. Do you have any other questions, ma'am, as to the court's rulings this morning?
First off, I did not forfeit my rights. That was your judgment. And also, I feel that I should have had some type of evidentiary hearing prior to your decision. So I could have better explained myself and you could have had a better understanding. So by you denying my standby counsel, which thank you to him for explaining to me what specifically it is, I don't want to be pro se any longer. So I didn't want to be pro se in the first place. And again, you, in my opinion, unlawfully denied me or didn't even suggest an evidentiary hearing in order for me to avoid or try to go about a solution or remedy so you would understand. So I don't know if it's me either wasting your time or anybody else's time, if it's even an opportunity or if it's just something that is denied, period.
It is denied, period. With regard to an evidentiary hearing, that seems to be in the realm of a Ferretta inquiry where a criminal defendant is seeking to represent themselves. And I would inquire of that person and have an evidentiary hearing as to the rights and remedies that you were forfeiting and the pros and cons of proceeding representing yourself and the benefits of being represented by counsel. Due to the Florida case law that was provided in the 16-page order, no such evidentiary hearing is required.
My understanding was the hearing, the Ferretta hearing is regards to competency as opposed to having an understanding before you take someone's right away.
Ferretta pertains to a criminal defendant's seeking to represent themselves. Ferretta was not applicable to your situation, and that's identified in the case law citations that were provided in the 16-page order.
Yes, I understand. It was the day of that I was explained most of all of this, and as opposed to prior, so I would know what happened or could happen. So my understanding is one thing, and then the explanation is another. So I'm just confused and feel that I should have had an opportunity prior to all of this to explain myself and to have a better understanding. So now my belief was that the evidence or the Ferretta hearing was simply competency. So the evidentiary hearing I thought would be a collaboration of the information of why I wrote my letters in order for you to remove my right to counsel. That, in my opinion, I felt that it was a type of retaliation by the court because you did not understand or attempt to understand any of my letters that I wrote previously, which was for the intervention of the judge and or the court to avoid any of this with me sitting in front of you present.
Ma'am, as identified in my 16-page order, I listened to every audio hearing. I specifically provided dates and times and words that were specifically said at particular hearings involving yourself and prior counsel. I also made reference in the 16-page order to statements that were made in your letters. I promised you, I've read everything in the court file. I've read every single letter, and I've listened to every single audio. That decision was not made lightly, and it took a lot of time to make that determination and that decision, which explains why it was also a 16-page order. That order stands, it remains. The court's not going to revise its findings or its determination as to your forfeiture, and alternatively a waiver by virtue of the conduct identified in that order.
Okay. I believe, in my opinion, the order is erroneous, and after I reviewed your 16-page order, there are quite a few incorrect entries, and some of them are based on perjury by the attorneys. And by you reading and then also listening to the audio, you did not listen to me in any way, shape, or form in order for me to explain myself better, so you have an exact understanding of the particulars of each letter for each attorney.
I'm not going to revisit my prior decision.
I understand. I'm just trying to make you aware that it's my opinion.
You, and like we talked about last time, ma'am, you're certainly entitled to that opinion.
Thank you.
All right. My judicial assistant has been in contact with the representative from the Orange County Jail Sergeant Donald Casey, who is on his way in order to facilitate the transfer of the USB drives from Prison Break Investigations. I do see that Mr. Lane is present. So as soon as he gets here, we'll be able to address that exchange. What we can do while we're waiting for that representative to appear is address some of the things that were identified in the notice of hearing for today, which is kind of a scheduling conference for when we might be setting up certain deadlines. As of right now, the trial is scheduled for October 7th. The trial will be extended from 2 weeks to 3 weeks. So the trial will take place on October 7th, October 14th, and the third week of October 21st. October 21st is not this division's normal trial week. However, the court has obtained coverage for that week so that should this trial proceed into a third week, we will not have to scramble in order to find coverage, and that we'll be able to efficiently proceed with any evidence or testimony on that third week on October 21. Pre-trial was scheduled for September 24th at 1:30. The court typically has its regular trial case managements on that Tuesday. Due to Ms. Boone representing herself and some of the complex issues that may be involved in this case, I'm inclined to change the date of the pretrial so that we might be able to have our own pretrial separate and apart from all the other cases that may be set for that same trial period. My thought would be to move it to, rather than the Tuesday the 24th, to Tuesday the 26th at 9 a.m.
Is that a Thursday?
Yes, sir. That's Thursday.
That's acceptable to the state.
Ms. Boone, that would give you additional opportunity to prepare for trial as well. Are you amenable to changing that date to September 26th at 9 a.m.?
So an additional 2 days?
Correct. You would still have that time to prepare regardless if we had the hearing on September 24 or September 26th. I'm just moving it so that we don't have 50 or 60 other cases and I can focus more attention on your case specifically.
Of course.
Okay, all right, so pretrial will be rescheduled till September 26th at 9 a.m. One of the issues that I wanted to address was deadlines for production of the state's exhibits and the defendant's exhibits. Now, I'm mindful, Ms. Boone, that you have not reviewed some of the documents that may have been provided. I know most recently, Ms. Cashman spent 20 hours with you alone going over questionings and reviewing some of the materials. I don't know the breadth and scope of what was reviewed to you, but some of it may have been reviewed to you based on counsel's representations. State, I want to address with you first, because Ms. Boone hasn't reviewed the discovery yet, as to what your position is with regard to assembling or finalizing an exhibit list or your exhibits for trial.
As far as providing a list of the specific items that the state seeks entry of?
Correct. I do want it before pretrial. So let me just kind of lay the map for what the court's thinking. The court would have the state provide a exhibit list and a witness list by X date. Ms. Boone would have the opportunity to look at that list. We would then have a hearing where all of the exhibits would be shown to and provided to Ms. Boone. They would be provided on a USB thumb drive that could be utilized with a laptop at the jail. And then she could view all those exhibits here in open court. And then she would be afforded the opportunity to make an objections in writing to any exhibits at a later time by a certain date.
I guess one of the concerns would be that if the state identified specific items that we would seek entry of, depending on the course of the trial and the questioning, there may be other items that have already been disclosed in discovery that may necessitate being entered in, would potentially not be part of this original witness exhibit list. Items that were in the discovery, but if that makes sense.
That does make sense,
Yeah.
and I understand what you're saying. And that seems to be more of a fluid situation as to what may happen at trial, right?
Sure. I don't imagine the court's intent would be for the state to just produce the exact witness lists that have already been sent in discovery and just make a notation of every item of evidence. The idea would be to try to pare down.
That's exactly the idea. Now, obviously, that wouldn't foreclose you if something was produced in discovery and something that would not be relevant or admissible at a certain stage of the trial, but maybe later became relevant or admissible due to something that happened or something that was said. I would not foreclose the state, nor would I foreclose Ms. Boone from attempting to move that piece of evidence into evidence for the jury to consider. But it would be almost like a civil conference where you and opposing counsel would go over what your exhibits are prior to proceeding to trial. And I think that's important to do that so that Ms. Boone has the opportunity to view those in court so that's on the record as to what she's reviewed, and then give her the opportunity to provide any objections, if any, to any of those exhibits. And again, I wouldn't foreclose you if you want to use items A, B, and C, and that's all you intend on using. I don't know what you intend on using. I don't know what evidence you have. If you only want to use and only show A, B, and C, but are saving D, E, and F for later, depending on what happens, I won't foreclose you from readdressing D, E, and F. But it's just an opportunity to address what it is you think you're going to be seeking into evidence at this time.
So essentially,
Go ahead, sir.
So I think we could accommodate that if we could go around September the 1st for that, and then that would give her an opportunity to review that USB and lodge any objections, and then we could potentially address those objections and go from there.
Okay, and that would be September 1 to have the evidence viewing, for lack of a better word, or for the list to be provided?
For the list and the USB.
Yeah, we're going to make this work for an October 7th trial date, Judge. I think September 1st is probably about the right time frame to have this in-court hearing to begin lodging those objections if she has any. My next question is, are you expecting the physical evidence to be brought here into court by a CSI so that she can potentially open it? Or are we just talking about digital evidence and giving her a list of the physical items?
If there's physical evidence that's sought, I want her to have the opportunity to review it.
And we should be looking at the top of the month for September so that we can get this done.
Okay, all right. Ma'am, do you understand that what it is that I'm discussing right now, so that you have the opportunity to review the evidence that the state may be seeking into evidence in your trial?
Is it my understanding that they will supply me with a USB drive and then I am to review it while in court?
No, ma'am. So it's kind of a two-step process. So anything that's digital, that's not forensics or CSI or something that's tangible, will be provided to you on a USB drive. We also will have a hearing where all of the evidence, including any digital, electronic evidence, or any tangible evidence, CSI materials, will be shown to you in court, played to you in court, so you have the opportunity to review it here as well. Anything else will also be given to you on a thumb drive for you to review at your leisure based on the hours of 8 to 4 by the laptop at the Orange County Jail. And then we will have a deadline after we have this evidence viewing for you to identify in writing any objections that you have to any of the evidence that's been provided by the state.
So it's not a matter of any type of confidentiality. It is all done in the courtroom with everyone?
It would be in the courtroom, correct?
Are there going to be news cameras and photographers?
That's something I need to address. I do not want, because our jury pool is going to be coming from Orange County, I have concerns about the media's presence in the evidentiary viewing. So I may have to enter an order which would prohibit media access for the purposes of that hearing due to the nature of what is being produced and reviewed, so as to further prevent intimate details of the case being released prior to trying the case.
Understand that, Judge. Ms. Boone, not to turn the page completely, but I think it's pertinent to this discussion, has indicated through some counsel that had met with her recently that she wants to talk to the state out of the jail. And I was going to discuss that at the end, but perhaps to not waste the court's time, I don't know about bringing physical evidence out to the jail, but as far as the digital evidence, which will include autopsy photographs, which will include crime scene photographs, which will include videos, perhaps a different suggestion, especially since she has an investigator from Prison Break, is that we identify those files that we intend on introducing at trial so that they can review that digital evidence on their own in the jail, and we're not publishing all the digital evidence here in open court. That should allow her the opportunity to lodge any potential objections such as duplicative or any other objections she may want to raise about autopsy photos, so on and so forth, without exposing all of the digital media to the public. As far as the physical evidence, the state doesn't have any real concerns about the media covering that. She can open those exhibits, or somebody with scissors can open those exhibits for her if there are any exhibits she wishes open in the witness box where it's concealed from the media's eyes. So those are my suggestions, and then later we can turn to her request and put on the record how we would go about going out to the jail and meeting her.
The only concern that I have with that is I don't have a record as to what it is that she reviewed.
My suggestion would be that because this is in the context of plea negotiations potentially, I would be out there, Mr. Cacciatore would be out there, and our investigator would be out there, and we would record it. The conversation that we have, of course, and that would all be protected because it would be in the spirit of plea negotiations under the evidence code. And then we can all file in writing, the state can file in writing, these are the videos that we are going to use. These are the particular photograph numbers from the crime scene and from the autopsy photographs that we're going to use. And then we can have the defendant sign off on that as well, so that it's documented as to what was told that she would be facing at trial. And either she can review it with her investigator, or she can review it with us, being present, and then that way the digital evidence is now in the open.
Okay. Ms. Boone, what are your thoughts on that?
I'm a little lost. So it's an option of reviewing what the state has with my investigator, and then be able to come with the objections and everything.
That is correct.
I'm unclear on having all of my evidence being in sealed bags, and for me to be able to inspect them to be here in the courtroom. I don't know how the attorneys have done any of this prior, but I don't believe that it was in the courtroom. So I'm just trying to protect myself against the media. I'm not sure at this point what is even suppressible that is available on the internet. But at the same time, though, it is my understanding that I should have some right to privacy in reviewing the evidence. So I didn't know if my investigator and I are able to collaborate prior and view, and then come to court with everything finalized and ready to go to answer.
I'm certainly going to give you an opportunity to meet with your investigator to address it. The question is just the method of how to do it. The state's proposal is digital. They would meet with you, identify specifically digitally what videos, what photographs they intend on utilizing, and anything that may be physical, CSI, etc., would be addressed here in open court.
Just so the court and the defendant understands how physical evidence viewing would operate normally, the defense attorney and or her or his investigator would come out either to the sheriff's office or OPD's evidence center, whichever agency, and they come and view it, but it's done in the presence of the state, it's done in presence of law enforcement, it's done in presence of the CSI for the chain of custody. So attorneys don't get privacy when they're reviewing the physical evidence either. So that wouldn't really be any different than if she's doing it in the witness stand or wherever we deem suitable in the courtroom.
I think that's the most appropriate way to have the opportunity, ma'am, to review the evidence. I can't release that evidence to Mr. Lane to bring to the jail for your review because of the chain of custody issues concerning some of the physical evidence. So CSI would have to be here just like an evidence viewing at the sheriff's office or elsewhere where counsel just identified. And I cannot bring you anywhere else other than here, and I can't release you to anywhere else. So I think the only solution that we have is to have the evidence viewing here with regard to any of the physical evidence.
Why is it that it can't be transported anywhere other than here?
Because I cannot make a record anywhere else of what you saw or what was reviewed. The only opportunity for me to make that record is here in court.
What did prior attorneys do?
That was already identified by the state.
I know I'm trying to keep up with everything. What was the answer, please?
So an attorney who's doing an evidence view would come out to the law enforcement agency's evidence warehouse, for lack of a better term. And then in the presence of the state attorney, the CSI, and the lead detective, they look at the package, and if they deem any particular package worthy of opening and examining, they can do that. We can have the CSI bring butcher paper here so that any particular item can be opened, put on fresh butcher paper, and then changed out between exhibits so that there's no contamination. And then you can examine it. If Mr. Lane or any other representative from his organization is here, he will have the opportunity to photograph those exhibits once taken out of the packages. And that's essentially how an evidence viewing is conducted.
Thank you.
You're welcome.
And again, please, would the media be involved in that?
That's a conversation that I need to see if I can exclude them from participation or viewing that proceeding. There are rights where the media has to view proceedings in court, but due to the sensitive nature of what may be being discussed or viewed, I need to see if I can prevent media access. So without doing a little bit more further dive or research in that, I don't know if I can make that call at this time.
Yes, I have not heard of a case where the evidentiary hearing has been televised. So if you could please look into that, because I disagree with the media being involved in that.
I understand your position, and again, for the reasons that I stated earlier, I'm trying to prohibit as much as I can from dissemination to the public, especially some of the exhibits that the state may be seeking to utilize. We are going to go ahead and set the evidence hearing. The first is Sunday. September the 1st is a Sunday, and that is Labor Day. The court would be setting a hearing for Tuesday, the 3rd at 9 a.m. to have the physical examination here in court. At that time, if the USB drive or the, after our viewing here in court, state is at your position to then have that meeting with Ms. Boone and her investigator and your investigator under the plea negotiations or settlement discussions auspices to review all of the digital and identify what it is specifically.
We are happy to defer to the defendant's wishes on that. And I wanted to have that discussion. It seems like we're turning that discussion. So I'll leave it in Ms. Boone's court. My indication from one of the attorneys that she had discussed things with said that she wanted to have a conversation with us. And so I'm offering that up. In the past, with female defendants at the Orange County Jail, there are classrooms, or at least one classroom there, where we could arrange to meet. It would be a big enough room for 4 or 5 of us that would need to be there. And then we can discuss that, whatever it is she wants to discuss, and it would be recorded. And again, those portions of the conversation that are about plea negotiations and the evidence and whatnot in the trial, I believe under the evidence code would not be admissible to be used against her. And I can leave it to her when she wants that to happen. We can make arrangements to try and accommodate that. It should not take us very long at this point, given the age of this case, to select and identify which digital evidence exhibits we're going to use. It's simply a matter of getting rid of duplicative and irrelevant photographs from the scene and the autopsy. And I believe the videos won't be too hard to decide which ones to use. I don't know that there's a whole lot of other digital evidence.
Okay. All right, ma'am, do you have a thought on when you would like this viewing to take place at one of the classrooms at the Orange County Jail under the concept as identified by the state?
So this meeting is separate. This is prior before everything else.
What I would envision, to not waste anybody's time, is we can go out there and have this discussion. If there is a discussion to be had about plea offers, one of the other topics was other matters, so that's kind of ambiguous. I'm not sure what other matters are. And then also we can let her know and probably provide the court in writing a list of the digital evidence that we seek to introduce. And then that way, if she wants us to review those digital evidence items together with her in the presence of everybody, we can do that. Or we can let her, with the list of the digital evidence that we plan on introducing, review that as many times as she wants by herself and or with Mr. Lane.
I understand. So would I be leaving with the digital evidence today, or how soon may I receive that?
So the state needs to assemble that. So my thought would be to have that meeting, ma'am, on the 3rd of September. So we would have a hearing at 9 o'clock in the morning where the physical evidence would be reviewed here in the courtroom. As soon as that evidence was finalized and reviewed, the state with their investigator, yourself with your investigator, would then meet that afternoon at the Orange County Jail to address, as the state has identified or spoken about, any settlement negotiations, plea offers, and under the other category to address what the digital exhibits are. They would provide you those on a USB drive, and they would identify for them specifically what it is that they are seeking for you to review at that point in time and have the ability to review it afterwards.
We're happy to do that beforehand, and I just want clarification. By providing her the USB with all the narrowed down exhibits out of the discovery, are we providing it to Mr. Lane? How are we physically?
It would have to be provided to Mr. Lane,
Okay.
who would then have to provide it to a member of the staff at the jail, the names of which I have from the captain at the jail as to what persons are involved in the laptop process.
Thank you.
And then once that's done, I would require Mr. Lane to identify with a filing in the court, probably in the form of an affidavit, as to when, where, and how the USB drive was received by him, and when, where, how, and to whom it was delivered.
Thank you.
Your Honor, I feel uncomfortable with you supplying my evidence to the jail. So I don't know if there's a way that, I don't know if you are aware, but my jail phone calls have been released, and there's a lot of things that have been released from the jail. So I don't know, I do not feel protected by you all handing it to the jail. I know that Mr. Lane and I previously had worked on the laptop with USB drives that he has furnished himself, bringing in from the outside. So I didn't know, and I would feel more comfortable if there was a process or a procedure. I don't know who your names are from the jail. I do know the captain, whom I spoke to the other day regarding my laptop. But I would very much.
Who was that, ma'am?
I'm sorry?
Who was that?
For which?
The captain that you spoke to. Who was it?
D. Giovanni.
Okay.
There's multiple sergeants involved, and I did meet the gentleman who was supposed to be here today to pick up the USB drives. So I don't feel comfortable, please, with providing the USB drive of my evidence with things that have been leaked or released from the jail. So if there's a possibility, please, I would like for my investigator to have that and bring in with me prior.
If I understand the jail's protocol, which I read to you at our last hearing, the jail will keep custody of the USB drives and release them with the laptop as well. So I don't know how I can bypass that process that they've created, because the USB drives and the laptop, when it's checked out by you and when it's returned by you, is all going to be logged in their IMS system.
Right, it's simply a laptop. It's a very basic laptop where anyone affiliated with my case has any type of digital evidence they bring in with them from the outside. It's simply a basic laptop that we are able to utilize at the Orange County Corrections Department. That's how we have done that prior. So I don't know what it is different, and I don't know the jail protocol because no one's included me.
You were provided a copy of it through the court filing, and I read it to you at the last hearing.
Your understanding is different than my understanding because my contacts from the jail are telling me something different.
Who? What are their names?
There's multiple sergeants.
What are their names?
I'd rather not get involved with fear of harassment or anything from other.
Ma'am, I'm deferring to what the Orange County Jail and the captain that you identified specifically as to her memorandum to the court, which was read to you at our last hearing, which was sent a copy to you by a notice of service, and it was provided by U.S. mail. It was sent out last week.
I have yet to receive anything such as.
Don't worry, I have a copy to give to you this morning, just in case you have not received it.
Yes, the last thing I have is your order that you provided me with the implementation of your USB drive.
Okay.
Option.
All right.
So anything that you are speaking of in the meantime, I do not know, and it was served by process?
It was served by U.S. mail.
By U.S. mail?
Mhm.
Yes. I actually have 3 motions, if I may submit them to you.
In a moment.
Yes, in the process of, because the address that you are, I'm guessing, sending these to is incorrect.
I received your letter addressing the address issue. That's been remedied. So the appropriate legal mail address will be utilized. It was simply a clerical error, and that has been remedied. But regardless, I did read to you at our last hearing the protocol for the USB drive in the jail. The court is inclined to follow the Orange County Jail's protocol with regard to the USB drives. So the evidence, digital evidence that the state seeks to admit at trial will be put on a USB drive, delivered to Mr. Lane. That will be delivered to a representative from the Orange County Jail. And Mr. Lane will thereafter file a filing with the court in the form of an affidavit identifying when he received it from the state and who he gave it to, when he gave it to, and what representative of the jail he gave it to.
So it goes from the state to Mr. Lane to the jail.
For the purposes of indexing it, for the purposes of their records under the protocol, and then it will be available for your use.
So if I want to see all of my evidence digitally, I need to contact someone at the jail.
No, ma'am. The evidence that were in the 2 bankers box that Mr. Lane digitized for you is going to be provided to the jail. That's going to be provided with the laptop to you. And that's available to you from 8 a.m. to 4 p.m. every day in the protocol that I read to you at our last hearing.
Yes, and I will speak to the captain just to be aware that everyone that it is in the process, because I do not feel comfortable with any of this, and I do not feel protected either by the courts or the jail system. So for right now, I don't know if it can be postponed or if it's something that I need to write another letter to. Everything takes longer in jail. So by me trying to get a hold of the captain nonetheless, it's going to be a feat in itself. So I want you to know, if anything, that I am in the process of trying to reach out to the captain. I don't know if she'll be here today or if it'll be the contact person. So in the process, I am working on speaking to the captain because I do not feel, like I said, that I am protected in any way, shape, or form by the Orange County Corrections Department withholding my evidence in any way, shape, or form.
Okay. The court's going to follow the procedure as I outlined at the last hearing. So here's what we will do. We will, on Thursday, September the 3rd at 9 a.m., we'll have a hearing to review the physical evidence. At that time, the state will provide its exhibit list, which will be filed with the court at that time, and a copy will be given to Ms. Boone of the physical and the digital evidence they are seeking to admit. After we have the in-court examination of the physical evidence. That afternoon, there will be a meeting at the Orange County Jail between the state, its investigator, Mr. Lane, Ms. Boone, to review the digital evidence and provide a USB drive with that information.
You can caveat in that order be unless it hasn't already been done. In case we do it ahead of September.
Sure, if you want to do it before, the deadline to do it will be to September 3. But the in-court physical examination will be at September 3. So if you all want to meet in advance of that, I won't prohibit that. Just file something in the court file identifying a notice or some document so that it identifies when that meeting took place, when the evidence viewing took place. Okay, thank you very much. Ma'am, after we've had this hearing on September 3, and that being the deadline for the digital evidence and the viewing of the physical evidence, the court would then like to set a deadline for when you would provide your objections to the state's exhibits. Mindful that this will take place on September 3 and that we have pretrial set for September 26th. And if we need to have a hearing with regard to those objections, my thoughts would be to give you 2 weeks until the 17th to lodge your objections. And those would need to be provided in writing by the 17th. So that if there are objections and if we need to have a hearing on them, that hearing can be held when we have our pretrial on the 26th. That would give the state ample opportunity to prepare for any of the objections that you have.
Forgive me, and thank you for your patience, everyone. So on September 3rd, I will be viewing the digital and physical evidence here in the courtroom.
Correct.
And then later that afternoon, I would be meeting with the state and my investigator.
If they don't meet with you prior to that date. The deadline for the state's investigator, your investigator and yourself to meet to review the digital evidence would be no later than the close of business on September 3. I've outlined for when I would like it done, but if the state wants to meet you in advance of that date, they can do so.
Yes, please. If I may ask, please, what is your name, sir?
William J.
Could you spell your last name, please?
J-A-Y. Don't get asked that a lot.
And what is your affiliation with the state?
I'm the homicide unit chief.
Yes, please. And I am okay if you would like to meet prior, so less time is consumed on the day of our meeting, supposedly on the 3rd.
So I assume you have availability. Should I meet with Mr. Lane to discuss his availability so we can get out there this month?
Yes.
Then you can do that. And like I said, Mr. J, if you could follow that notice,
Yes,
just
sir.
identifying when, that would be most appreciative. So ma'am, understanding where we are with the viewing, what is September 17th for the deadline for your objections acceptable to you?
Yes, and if I may please raise the point that I have a motion here in regards to going in the process of looking on it for the laptop. I do not have my discovery as of yet, and I do not have the laptop as of yet. I do not know what hiccups may be involved. There's a lot of hiccups with the jail already. So I'm trying to figure out when and where are we able to view anything. So there's a great restriction also that is being put on the laptop usage from 8 to 4. I'm unable to utilize my time to the full extent. Also, I have a motion here to receive my hard copy evidence because when the laptops are in quotes, the laptop is in quotes, closed for the day at 4 p.m., I can therefore pick up using the hard copy evidence.
I haven't had the opportunity to review the motions that you're speaking of, neither has the state. We'll address them today. I don't have a problem doing that. I'm just not going to do it right this second because I haven't had the opportunity to review them yet.
Yes, and I'm just explaining myself in the meantime, please, so you're aware of what I have already thought of and am trying to ease the pain of everyone with me trying to figure out how to do everything and when and do it appropriately. But I just wanted you to know that by bringing that topic up, I have that to also be looked over.
Okay.
Please. 917, if that has to be changed, am I okay to do that?
I'm trying to set deadlines now, ma'am. And that will give you 2 weeks to review the physical evidence, you'll be provided the digital evidence, it seems, in advance of that September 3rd deadline. And that may give you more than 2 weeks to review and lodge any objections.
This is just for the evidence?
Correct. This is only addressing any objections to the evidence that the state seeks to admit.
The digital discovery, is any of that included in that?
Yes.
Okay. I am very weary to make these type of deadlines.
Well, we're setting them today,
I understand. So the 3rd is a what day? Thursday?
Tuesday. So the 17th would be 2 weeks later, Tuesday the 17th.
And that is me coming with my objection.
That would be you filing your objections in writing with the court. And to the extent we would need to have a hearing on those objections, we would have them when the pretrial or trial case management conference is set at 9 a.m. the following Thursday, the 26th of September.
I'm sorry, what is on the 26th?
That's when we're having our pretrial or trial case management to address any last minute issues regarding trial.
Forgive me. So today being August 5th, I'm supposed to expeditiously complete my case that in every way, shape, and form by September 26th in order to go to trial for October 7th.
The dates are what the dates are. September 26th is the trial case management date, and October 7th is the trial date.
So by me not even seeing my discovery yet 2 days, and only being restricted to a laptop from 8 to 4 and not having my hard copy evidence.
You have 62 days to prepare for trial, not including today. And you're going to get your discovery today.
Wow. So in over 4 years, it comes down to me representing myself in 62 days?
I'm not going to answer that question.
Am I supposed to?
What now we're addressing, ma'am, is September 17th,
Right.
the deadline, which is 2 weeks after having the physical view of any of the physical evidence. It sounds like Mr. J is going to try to meet with you pretty promptly regarding the digital evidence. So you'll have plenty of time to review that in 2 weeks at a minimum, or 2 weeks at most rather, to lodge any objections to the physical evidence.
I understand. I just don't understand how to file objections.
I cannot answer that for you. That would be me providing you legal advice, which I'm prohibited from doing. All I can tell you is that if you have objections to any of the exhibits that the state may seek to move into evidence, you will have to lodge those objections by the close of business on September 17th. And those objections will have to be in writing. If we have to have a hearing on those objections, that hearing will be held on September 26th.
Okay. And if I may ask, are these being delegated or I'm being incorporated in this in order for me to be able to say yay or nay?
I don't know what that means. What do you mean delegated?
Are you delegating to me as you delegated everything else in regards to taking my counsel and all of your orders?
You are representing yourself for the reasons that the court identified in its 16-page order. It is your responsibility, as you are representing yourself and proceeding pro se, to comply with the court's orders and deadlines. So if you have objections to any of the exhibits that the state may be seeking to offer into evidence, be it digital or physical, based on your review of those, the deadline to submit those in writing would be on September 17th.
Okay, so you're making statements, so I don't have any say in it.
I've asked you what your thoughts would be as to when. You've never provided me in a disagreement with regard to that date as of yet. You've asked questions about your motions that I haven't seen yet, your desire to have hard copies, which we addressed at the last hearing, but I'll be glad to address it again today. You have yet to tell me that that date's unacceptable for you, and if so, why?
I wouldn't necessarily say unacceptable, I'm just uncomfortable with agreeing to a date when I am pro se and have never been pro se before and do not know what I'm doing. So I just want to make sure that I do it correctly and have an understanding also if you are proposing that I go to trial within 62 days, that I know what I'm going into and what I may expect. So I didn't know if this would just be easier on everyone else, if they just delegated the date and gave me a printed copy with your order and whatever information you have. I don't know. I don't know either if you all are just proposing that because I'm incarcerated, just the dates are what you tell me. I don't know what I'm doing. I do not know what I'm doing. So I'm trying to learn as I go, which is why I'm grateful for everyone's patience. But at the same time, though, for me to accept this date and then not be able to meet it, what happens when that happens, if it should happen?
I can't answer that question. Again, that would be me providing you legal advice as to what to do if something happens. I simply cannot answer that question. I'm not allowed to.
Okay. Well, I'm with the court, so whatever it is that you all are trying to do in order to expedite this even more than what it's being expedited, I'm guessing I agree with September 17th.
Okay. All right. Now, ma'am, I believe that takes care of all of the deadlines with regard to the state's exhibits. Now I want to address the deadlines for any exhibits or witnesses that you may be seeking. I am mindful that you will be receiving the discovery today and that you have not had the opportunity to review some of the items that may be in the discovery. So how much time would you like to provide to the court the list of exhibits that you may be seeking to enter and the list of witnesses that you may be seeking to have testified in a defense should you choose to put one on?
Please understand that I do not have access to a normal phone. I don't have access to a normal phone at normal hours. So I am trying to overcome the hurdle of trying to, number one, locate any of my witnesses, and then also try to communicate with them on a payphone only telephone call that I do not have regular access to, and that are limited to only 15 minutes that I have to share with 62 other inmates. That is a hurdle please that I need for you to please take into consideration in order for me to be able to try to determine my witnesses, to determine any expert witnesses. May I ask, please, does the laptop have internet access?
I'm unaware. I'm unaware if it does.
To view any documents?
I'm unaware. I can't answer the question that I don't have an answer to. I'm unaware if it has internet access.
Whom is it that I need to speak to in order for this?
We may be able to inquire of the jail representative who is appearing for the hearing this morning, and if not, the captain may be able to provide that information, but I do not know if it has internet access.
May I ask your contact names from the jail?
Give us 1 second.
Please, and also because of the court's error of sending my information that you're referencing to the incorrect address, could you please provide me a copy of that also?
What is it that you're asked? Which, the protocol, ma'am? That was what was most recently sent.
I don't know. Whatever it is, the last thing that I received from you in the court was the hand delivery of the order regarding USB.
I have a copy that Madam Clerk's already printed out of the protocol. We will have the deputy hand deliver that to you right after. What I did? Yeah. Oh, I sent it to Anita. That's why. Give me a second. I'll have Madam Clerk print that out for you right now, ma'am.
Thank you.
So, understanding that as of right now, you do not have hard copies, you'll be provided digital copies, and to review all this evidence, ma'am, when in time do you feel comfortable in providing the court and the state the list of your witnesses and your exhibits that you may be seeking to introduce?
I'm going to go with to be determined because I just explained also, please, that I do not have access to a regular phone. I need to locate anyone. I need to do research. I don't know if I have internet access to anyone. I don't have a phone book. There's no way that I know how to do any of this without essentials and fundamental equipment in order for me to be able to provide you with those answers. I cannot promise anything because I do not know how I will be able to do any of that at this moment. I would like please to propose your understanding of a meeting that I would like to have with the captain so I can see if I can have access to a regular phone, if I can have access to an internet. Right now I have a tablet that is used for text messaging and movies and the law library that I utilize. I don't have access to the phone. I don't have access to the internet.
You can certainly have those conversations with the jail representatives. But ma'am, we were on notice today to address those deadlines, and I cannot set a to be determined deadline at this time. I understand that there's been some delays with regard to the discovery. As I told you at the last hearing, we're moving as expeditiously as possible to get you that, and it took some time for that process to be created. That process is going to start today. Mr. Lane's here. Representative from the Orange County Jail will be here. That handoff will take place. You'll have access to that laptop with all the information today.
If the defendant's not going to make a suggestion, make a state.
Sure.
My suggestion would be to give her 14 days after the point that the specific evidence identified by the state to be used at trial is provided to her. So, for example, the physical evidence, which we plan on giving her the list of those physical items well in advance of September 3rd. That will just be the date that she can actually see them. But my suggestion for those physical evidence items would be September 17th, and then 14 or 15 days after whichever day we get the specific list of digital evidence items to her, would be our suggestion.
Okay. Ma'am, are you amenable to that? That would 14 days after you've had the opportunity to review the digital evidence and 14 days after you've reviewed the physical evidence to provide your exhibit lists?
I don't feel comfortable with any of this. I don't have the same opportunities as the state or any attorneys prior. So I feel that you all are pressuring me and forcing me into these dates which I may not be able to meet or exceed.
Can I add that obviously either side, if there's good cause for why a deadline wasn't met, if something comes up, then we're not prohibited either side from complying with the rules of discovery afterwards. But there would just need to be a cause shown at that point.
Do you understand that, ma'am?
I do.
That I'm setting these dates for now, and if either party can establish good cause why these dates should be moved.
Yes, and that is why I'm trying to make everyone aware prior to all of this to understand my circumstances by being incarcerated and not having access to a phone, not having access to the internet, and not having access to many more other, like I said, basics, fundamental basics, which is why I'm making you all aware now, so you are aware that when the time comes, should it, why for good cause, I'm stating my good causes now, if not, there are additional at that time.
Ma'am, as of right now, the court is inclined to agree with the state's suggestion that 14 days after viewing the digital evidence, which will take place no later than September 3rd, sounds like it'll take place way in advance of that, you are to provide in writing your list of exhibits that you want to attempt to move into evidence. 14 days after viewing the physical evidence on September 3rd, you are to provide in writing the list of any exhibits that may be physical that you intend to enter into evidence. Those dates can be extended for good cause that may be shown. State, would you like the opportunity to review those exhibits similar to an evidence viewing that we're having with Ms. Boone reviewing the state's exhibits? Would you like a similar opportunity to review any of her exhibits?
If the defense has any physical evidence to place in evidence, I can make those arrangements with Ms. Cohen.
Okay, all right. I will set a deadline for the review of September 26th.
Thank you.
Is the review that you're speaking of, please, for my executive witness list?
That is correct. I would also propose a similar date of September 17th for any of the witness lists for the defense. And Mr. J, would you be in a position by the 1st of September to provide any witness lists for the state?
She should have the witness list in the discovery that's being provided. As far as the order and the list of witnesses that we're going to call at trial, we will get in that ahead of 9/3.
Okay, all right. So the deadline for the state's production of the witness list will be September 3, no later than, and September 17th for Ms. Boone. Ma'am, similar to the objections to any discovery, that'll have to be in writing as to who it is that you may be calling as a defense witness. And you'll have to provide that to the court in writing by September 17th.
Yes, and if I may ask, please, what you're typing, is that for an order or for today's proceedings?
It is for an order, which you will be given a copy of. It may not be able to be hand delivered to you, ma'am, because I'm gonna have to move some stuff around based on my scratch notes here, but at a minimum, it would be mailed to the your proper address. Due to that clerical error, that will not be an issue.
Wonderful, thank you.
Okay, I think that addresses all the issues with regard to production and hearings on any objections. Anything else from the state that you believe we need to address from a scheduling concept?
We're good with the scheduling concepts. Thank you, Judge.
Thank you. Ma'am, do you have any questions with regard to the scheduling concepts or deadlines that we've addressed this morning?
Other than what I have made known to the court, I do not.
Okay. Bruce, can you see if Mr. Sergeant Casey's here? He is here.
Your Honor.
All right, very good. Sir, could you come on up, please? Madam Clerk's going to go ahead and swear you in. You can stay to the podium, sir. No, just the podium, Sergeant.
Oh, sorry.
If you could raise your right hand, Madam Clerk's going to go ahead and swear you in.
You swear or affirm that the testimony you give shall be the truth, the whole truth, and nothing but the truth, so help you God.
All right, sir, good morning. Could you state your name for the record?
Sergeant Donald Casey.
And what's your position at the Orange County Jail?
Sergeant.
And what are your duties and responsibilities, sir?
I'm over transportation, downtown port holding, BRC courts, medical security, and the juvenile assessment center.
Okay. Are you aware of the protocol that Captain DiGiovanni created with regard to Ms. Boone's use of the laptop?
I am.
Okay, all right. Have you had the opportunity to review that protocol?
I have.
Okay. Mr. Lane, can you come on up here, please, sir? Sir, good morning. Could you raise your right hand? Madam Clerk's going to swear you in.
You swear or affirm that the testimony you give shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, sir, good morning. Could you state your name for the record for me?
Billy Lane.
And what's your affiliation with Prison Break Investigations?
I'm the owner and chief investigator.
All right, sir, last time I saw you, I had tasked you with digitizing 2 bankers' boxes of information. And you said that you would endeavor to accomplish that task by today, understanding that you were out of town for your son's wedding. I hope you had a great time. Were you able to fulfill that task, sir?
Yes, sir.
Okay. How many jump drives or drives do you have?
Of the digitized information, there's one of those. This drive here is a copy of all digital discovery that I have in my possession from Ms. Boone for the court's needs if they wish to facilitate that through the, figure it'd be easier to facilitate it now through the jail than me trying to bring it in myself.
That's exactly my thought. So you've shown to me, sir, a small thumb-sized USB jump drive. That USB jump drive is the information that was contained in the 2 bankers boxes, correct? And the other jump drive that was the larger of the 2, that jump drive is any digital information that you've had previously by virtue of being the investigator.
Yes, sir.
Okay, all right. The record's going to reflect that information is going to be hand delivered by Mr. Lane to Sergeant Casey. So Sergeant Casey, if you could please take custody of those 2 thumb drives. And I'm going to ask you, sir, to comply with the terms of the protocol, to have those added to the laptop. It'd be available for Ms. Boone's use today once she's returned to the Orange County Jail. Do you have any questions for Mr. Casey?
No, Your Honor.
Okay, sir, thank you very much. If you can proceed with that task, I appreciate you. Thank you. Mr. Lane, you took custody with you, sir, as well. Well, before you leave, Sergeant Casey, state, do you have any questions for him?
No, Your Honor.
All right, ma'am, do you have any questions for Sergeant Casey regarding his compliance with the protocols provided to be by the captain of the jail?
Mr. Casey, could you please make note to Captain Giovanni that if she has time at some point, as soon as possible, to please sit down with me for about a half an hour to go over quite a few things that I need to have resolved?
I'll inform her.
Please, in regards to the laptop.
Okay.
Thank you.
So just an example of where I think I can understand some of the frustration. The last hearing, she says, the judge says he hasn't gotten some of her motions. And then when she asks how to communicate with him more effectively, he says, just mail them. But he had just said he didn't get them, and it was 5 days after. You can kind of understand why she gets pushier, because if the answers don't work out, how would you feel?
Thank you very much, sir. Mr. Lane, when we were last here, you also had 2 banker's boxes. Did you bring those back with you, sir? Okay, could you bring those back up? I do see it looks like the original exhibit tags are still on the top of those. Mr. Lane, did you complete and copy everything that was in both of those boxes?
Yes, sir.
Okay, I'm gonna have Madam Clerk take possession of what was pre-marked as A and B for the purposes of the June 28th hearing, and we'll hold those into evidence. Do you have any questions, Mr. J, for the investigator with regard to his task?
No, Your Honor. Thank you.
All right, ma'am, do you have any questions with regard to your investigator regarding his completion of the digitization process?
And my only question is, Mr. Lane, do you know when you would be coming to meet with me at the jail?
It's going to be my intent to try to get out there at the end of the week or beginning of next week.
Thank you.
Thank you, sir. I appreciate you.
One housekeeping thing.
Yes, sir.
I don't know if Mr. Blake, since he's here, would like you to sign my invoice or have Ms. Boone do it since she's pro se.
I don't feel comfortable signing your invoice. I think Ms. Boone would have to sign it.
Okay, that's fine.
Okay.
Is it okay if I?
Hand it to the deputy. Deputy will have her sign it, and then you could take it. Mr. Lake, is that acceptable, sir? Counselor, you're muted.
Yes, that would be acceptable, yeah, if Mr. Lane, and Your Honor, in light of this, maybe it might be more appropriate for the court to go up to 10,000 for the investigator, because it sounds like he's already done a lot of work. So it might make more sense instead of having to come back later.
Would that change the original, the 5,500, or just we would increasing 5,000 to 10,000?
5,000 to 10,000, I think would make sense, Your Honor, just because it sounds like that we may, based on what's already been done, and Mr. Lane may have more to say about that, but based on what he's already done, I suspect he's probably used a large chunk of that 5,000 just doing this one task.
One thing I would like to add, Your Honor.
Yes, sir.
In lieu of having to come back and file another motion, is if JAC would agree to travel expenses and some out of county. If not, I can get that in some type of form of a writing and get it to you or to the JAC if that's acceptable.
Mr. Lake?
Your Honor, we'd have no problem with the court authorizing, saying that $1,000 for travel expenses as well.
All right, fine. So we'll increase it from 5,000 to 10,000 for investigative costs, and for travel-related expenses, 500 to 1,000. Mr. Lake, are you going to need an order for the court file with regard to those?
We would, Your Honor.
Okay, could you submit that?
Yes, Your Honor, we will prepare the order and submit it.
All right, very good. Just send it to Ms. Barrios, who I believe you have her contact information.
Yes, Your Honor.
All right, very good. Thank you, sir. Mr. Lake, thank you so much, sir.
Yes, sir.
All right.
Judge Freeman,
Yes, ma'am.
forgive me. What is his name, please?
That's Christian Lake. He is an attorney associated with the JAC, the Judicial Administrative Commission, regarding costs for indigent defendants. All right, state from a scheduling perspective or the protocol, which I know I filed a notice of filing of, I'm sure you've had the opportunity to review it. Anything else we need to address from that?
We're good on scheduling, Your Honor. Thank you.
Okay, thank you. Ma'am, anything else we need to address regarding scheduling or the protocol other than what you've already addressed this morning?
Will my investigator be present at anything for and with me?
I can't speak to for or anything, but based on what we discussed today, your investigator will be there for the digital review, which will take place no later than September 3rd.
Okay, yes, I would like to have some type of witness from
He will be
the site
there.
also.
He will be there. Mr. J is going to be recording the conversation as he identified previously.
Thank you.
Now, ma'am, you made reference to some motions that you may have brought with you this morning.
Yes, please.
All right, if you could hand those to the deputy. Also, to the extent that the deputy has not already done so, I printed out a copy of the July 24th, 2024 protocol regarding your use of the laptop at the jail. And I'm going to ask the courtroom deputy to please hand deliver a copy of that to you. It was mailed to you, it was read to you at the last hearing, but now you have a physical copy of it, ma'am, to the extent one was not already provided to you.
Oh, yes, I have not received this yet.
Okay.
And then also there was another printout that she was going to provide me with, which I believe was a memorandum for today's dates.
I haven't, she being who, the captain?
Oh, no, I'm not sure her name.
Oh, Madam Clerk, no, the only thing she's printed out for you right now, ma'am, is that protocol. I'm going to be finalizing the order. And like I said, I may be able to finish it before we're done with the hearing, and I'll hand deliver it to you. If I cannot, it'll be mailed to you.
Yes, I understand. It was regards to another document proposing the dates for today's hearing. And I guess it was some type of notice. That's what reads that she was going to print out to give to me, so I have that.
Okay. Mary.
I did not receive that, nor did I receive this protocol list.
As to everything that was being discussed, can you print out a copy of it first? It should be in the court file. All right, ma'am, let me take a moment to review your motions. Give me a moment here.
Thank you.
Well, ma'am, with regard to one of your motions, the motion for defendant's immediate address correction, as identified earlier, there was a clerical error using the general PO box as opposed to legal mail. That's been remedied. So I'm going to go ahead and grant that motion as that's already been remedied, but I don't have a problem granting your motion for the correct address for any legal mail. Mr. J, if you want to approach, sir, to review the hand-delivered motions. It is the motions for defendant's reasonable freedom and movement by allowing her to be unshackled, unhandcuffed, to function equally and comfortably while utilizing the courtroom. Second motion is the motion for defendant to lawfully receive, review, utilize the original hard copy discovery, parentheses, 2 boxes, -A, B, parentheses, submitted to the court by former attorney, parentheses, S, and parentheses, on June 28, 2024, for preparation of trial in her criminal case. Just review those, Counselor. Just let me know when you're ready to address them.
Your Honor, in regards to the first motion, we need to notice the Sheriff's Office, who is in charge of courtroom security. So we're not able to address that today unless they're allowed. I don't know if you're able to contact the person that's in charge of that today. Otherwise, we would need a separate day for that motion.
Okay.
As far as the second motion, it's completely up to the defendant. We have no standing to say anything about it. If she wants to have her documentary discovery in hard copy form, that's between whoever and whoever, but not the state of Florida.
Okay. All right. I appreciate that, sir. Ma'am, with regard to your request for discovery, of the hard copy discovery, you've advised me multiple times seeking to use a laptop. I've written correspondence from you asking for a laptop. That laptop is being provided. At the last hearing, you advised that you wanted hard copies. You've also advised me that you live in the female dormitory, you have limited to no privacy, and you have nowhere to store anything. You have a small drawer to keep personal effects, and that's it. There's nowhere, is my understanding, in communications with the captain to place this information. There's nowhere to house it. There's nowhere to store it. You do not have, by your own admission, any place to place it.
Is that your understanding now? Are you asking me?
No, those are just statements that I know that are in the court file that you've made. You've written letters requesting a laptop. That's been provided to you.
I've never.
You have written letters, ma'am, specifically asking for a laptop.
Do you know what the date of that is?
Without me going through all the correspondence. But when we have our hearing on the issue of the your motion for freedom and movement, well, I'll notice the sheriff, and we'll try to set that up for this week so that it can be done expeditiously.
Okay.
We can address that at that time. But the jail has advised me they have no place to store this information, these hard copies. You've advised me you have no privacy and nowhere to place them. So I'm not saying no, but I don't know how I can facilitate this for you. When you do not have a place to store it, the jail does not have a place to store it.
We have an entire property department for all of the inmates on the entire compound. I've been given permission also by sergeants.
Who?
Corporal Ward, Sergeant Dunn, Sergeant DeJesus, have the understanding that I have been forced to represent myself as pro se and have temporarily given me a property bag where I can store additional case documents at my bunk. Help me understand, please, for future reference, so I know how to approach. By my statements that I have made to you, questions were not asked in order for you to come to the conclusion that you are coming to that I did not want my hard copy. I was never formally asked by you to see if I wanted my hard copy discovery. I would believe it was the court's understanding, the judge's understanding, that it should automatically be allowed to give to me. My understanding and trying to explain to you also, so you have an understanding, is my limited restricted access to the laptop is from 8 to 4. I, with 62 days left in order to defend myself in preparation for trial, would like to close that laptop at 4 p.m. and then pick up the discovery hard copy in the 2 boxes that I have. I haven't spoken to the captain yet. I just now received the protocol for the laptop. I know that you had mentioned it to me the last time that we met with one another. So I'm confused how everyone is confused by me coming to the court with solutions and ideas and suggestions, but are being misinterpreted and misconstrued like my letters from my attorneys, and you're coming to the wrong conclusion.
I'm not coming to any conclusion. The process was created, and I'm just reciting what you've said to me at prior hearings, ma'am. That's all I'm doing. You've told me you have limited space. You've told me that you have no privacy and that you have a small drawer for personal effects. This is the first time I've heard anything about you having a locker or some kind of bag or property bag that you now have access to. That wasn't addressed at our last hearing. This is the first time I'm hearing about it. So I'm not drawing any improper conclusions, as I identified for you with the process. The jail created this process. It was something that they put together. And as I told you, we worked diligently to move forward, to get with the jail to have this done. There's no nefariousness here. There's no undermining. There's nothing along those lines. I want you to have this information. And as I addressed at the last hearing, I could not copy it. I can't look at it. I can't look at what's in those 2 bankers' boxes. Ms. Barrios cannot. No one associated with my office can look at it. We had to use your investigator to do that. And what the jail has advised me is that they were not in a position to take both those bankers' boxes because of space and potential hazards. Now, if something has changed and the captain advises me that you can have those documents, I don't have a problem with you having them. But what I've been advised, as identified in that protocol, is to how and when you can have access to the information. And unfortunately, it wasn't in physical form, it was in digital form. And that was the process that the jail created. They are aware it's 2 bankers' boxes. They're aware of what the information is. Everything has been out in the open to address your concerns and how to facilitate getting this information to you. No one's withholding anything. No one's trying to hide the ball.
My opinion differs. I was never asked anything, just like my letters to you prior to you forfeiting my right to counsel. I was never asked anything in order for you to have a better understanding.
Ma'am, I'm not going to revisit that.
I am not, you never asked me in regards to the hard copy.
Hang on. Yes.
How quickly can we have an evidentiary hearing with the captain or whomever we need?
My understanding is she's on vacation this week.
Okay.
So, which is why Sergeant Casey was here, because Captain DiGiovanni is on vacation. And I cannot recall off the top of my head when she's set to return. She's set to return on the 12th.
So if the document, what would be the process? Because it's marked, tagged, and in evidence, so there would need to be a motion to get it released from evidence.
I mean, I would entertain an or tennis motion to have it released from evidence. The concern as, and Mr. J, this is the first time I had the opportunity to discuss this case with you. I know I've been dealing with Mr. Cacciatore. We had a hearing, and I'm sure you're versed on this, but let me just kind of bring you up to speed. We had a hearing in June, and at that point in time, I forfeited Ms. Boone's right to an attorney based on her conduct and alternatively a waiver. And I'm sure you've read it. Thereafter, the court endeavored to figure out how to get those 2 bankers' boxes that Ms. Cashman had provided to the court at that hearing in Ms. Boone's possession. It took time for the jail to come up with a policy and a procedure for that to happen. I was advised by the captain that they could not take custody or possession of those 2 bankers' boxes because of A, storage, and B, because of the hazard. Now, if the jail is in a position to revise that by virtue of Ms. Boone identifying a property bag or something that may be available for her use, I am 100% on board. If the jail says, yeah, we can facilitate and make that happen, her getting that information. I'm just traveling with what I've been provided, and the protocol that was provided to me that's been filed in the court file was not inclusive of providing her hard copies.
I understand. I'm just trying to find a solution. So
Same.
If she moves Oritanis to release those 2 exhibits to her investigator, then perhaps he can try and get them released to her. And if he cannot, then it sounds like on the 12th, we can revisit this when the captain's back.
I think I don't know if she returns on the 12th or that's when her vacation ends. It's a Monday, so I'm assuming she'll be back, but I don't want to make any affirmative statements on that. I don't have a problem. Mr. Lane's had this discovery. I don't have a problem with him taking custody of it again. And if he's able to deliver it to the jail and they allow it to be released to Ms. Boone, I don't have a problem with that. I have no problem with it. I'm just traveling on what the jail has advised the court in the creation of this process.
Okay, so if she wants to Oritanis, which means oral motion, move to release those two exhibits. The state has no objection, and it sounds like if Mr. Lane can't get them to her, we'll be able to revisit this in the near time future.
Yes.
Just so that she's advised. So I don't want to ask her, but perhaps the court can ask her that question.
Ma'am, the state has recommended a position for, in an attempt to get you these hard copies. Is that something that you would like the court to, would you like to follow with the state's suggestion and ask of that of the court orally this morning?
I'm not understanding what it is that he's trying to do. May I please propose that the hard copies go to Mr. Lane, and then once I have permission by the captain and whomever, you can release them to me?
Granted.
No objection to her motion.
Okay. Mr. Lane, thank you for staying, sir. I appreciate you. If you could come back up here, sir, and take custody of both of those banker's boxes. I will have Ms. Barrios coordinate a hearing for the 13th at 8:45. Why not? We cannot do it the 13th because it's pre-trial. You're correct. We will have a hearing on August 14th, if necessary, on Wednesday, August 14th at 1:30, if we need to address the jail's position in taking hard copies if Mr. Lane's unable to have it delivered. And Mr. Lane, you had advised earlier when Ms. Boone had inquired of you as to when you might be able to go visit her. You said the end of this week or by next week. If when you go to visit her by the end of this week or next week, bring that with you and see if the jail would be in a position to take it. If they are, I'm going to ask you to file a similar notice, sir, that that information was provided to the jail on what date and to whom. Okay. All right. Thank you.
Your Honor?
Yes, ma'am.
What would the hearing be for on the 14th then, for the jail taking?
The hearing on the 14th, ma'am, would be if Mr. Lane is unable to have the jail take physical custody of those two boxes for your review outside of the laptop,
Yes.
we would have a hearing to address what, if any, protocols the jail may be able to utilize in you having those documents. It may not be necessary. We're going to go ahead and set it if we need it. If we don't need it, we will not have a hearing.
Thank you. And then so there would not be needing to be made an updated evidence control sheet right now. It has been passed to Mr. Lane.
As of right now, the court minutes are going to reflect that what was pre-marked as A and B from the June 28th hearing is being provided to Mr. Lane.
Thank you.
Okay. With regard to your reasonable freedom motion, I'm going to set that for this Friday. Is the state available at 8:45 on Friday?
No, what's that date, please?
That is the 9th, ma'am.
We're available, Your Honor.
Okay. Ms. Barrios will coordinate with a representative from the Orange County Jail to address the reasonable freedom motion. Ma'am, I'm going to hand file both of these motions with Madam Clerk, okay?
Thank you.
All right. Is there anything else we need to address this morning, State?
Not from the state.
Anything else we need to address, Ms. Boone?
Please bear with me, just please, 1 moment.
Uh-huh.
What was the conclusion for the sensitive issues of having the media incorporated in the courtroom?
I need to research that matter a little bit further before I can make an order that would prohibit media access.
Do you know what your deadline may be or estimated?
It'll be well before the 3rd. That's deadline is set for September 3rd at 9 a.m. when we'll have that viewing. I will endeavor to get that done as quickly as possible. Ma'am, you also had asked for a list of the persons that Captain DiGiovanni had provided. The names of the persons at the jail regarding the laptop protocol is Captain Giovanni, Donald Casey, who was here this morning, Stephanie DeJesus, Sonia Robinson, Courtney Battle, and Malik Muhammad.
Thank you for that. Would you be able to provide me with a hard copy?
I will put that in the order that'll be mailed to you, ma'am.
Wonderful, thank you.
Okay.
If I may, I don't know if I'm allowed to address the state directly.
Yeah, you're representing yourself, absolutely.
How do I go about getting a copy of my phone or utilizing my phone? Is that something that can be brought to the courtroom, and during the evidentiary, the physical evidence that I might be able to utilize that?
So my understanding is there was an imaging done of your phone with software called Cellrite, and that is part of the digital discovery that has been provided to you. If you are talking about the physical device being re-examined by your own expert, then you would need to find and retain your own expert to do that without giving you legal advice or suggesting that he is the person you hire. I know that defense attorneys in this area hire somebody named Richard Connor, Connor, and then that will be between you and the JAC and him, whether or not he wishes to work for you and at what rate, so on and so forth. And then that examination would be done by him, with us being present if we want to be present.
Yes, I have reviewed, I believe, 2 or 3 different thumb drives were given to me at one point, where I researched all of them extensively, also included with Mr. Lane, and it is nothing of use. It's primarily cookies and history and so forth. So that's why I don't understand who it is, the legal expert that can give me a near download of my entire phone in regards to videos and pictures and contacts. I could probably supply a witness list sooner than later if I were to have accessibility to my phone in regards to my contacts. That's why I didn't know if it would be allowed to have my phone physically here in the presence of everyone, including law enforcement, to be able to physically look at my phone and go through it and to see what I can extract myself while here in the courtroom before trying to figure out how to locate and contact an expert to download all of that to receive.
So all of that information should have been downloaded, and I'm not sure what has been provided to you, but we will be double checking that.
It has not been provided.
Yeah, your contact information, all the videos and photographs, everything on your phone should have been downloaded. And what you may have reviewed is just a PDF file called the timeline. There is additional data there, and we will make sure you have that. And then when it comes time to our digital evidence deadline, which I hope to exceed well before 9/3, we will be identifying which portions of it is of your phone, if any, that we seek to introduce at trial. So it may be texts from December 2nd, 2019, whatever it is. We will identify those pages, we will identify those files, because obviously your entire phone, however many gigabytes it is not going to just come into evidence. Because like you said, there's so much of it that would be not relevant.
Yes, thank you. So you all have already had access to my phone and have researched it fully?
We're not going to talk about our work product. I'm telling you what, based on my experience from other phone examinations is, all that information should be there. And it's typically presented in 2 different fashions. One is a large PDF, typically hundreds or thousands of pages, depending on how much you use your phone every day. And then there's a separate big digital image file that is read with what's called a UFED reader. And then that is where you can go in and look at everything.
Yes, sir, thank you. I've not seen any of that.
We were going to make sure that that's taken care of.
And that, just as clarification from the court perspective, is that something that would have been provided in discovery to prior counsels?
Yes.
Okay, then ma'am, as Ms. Cashman identified, she had everything. It's already been digitized for you, and to the extent you're able to have the hard copies, it'll be provided to you. So you'll have access to all that information today when you return to the jail.
Yes, thank you. None of it was gone over in any way, shape, or form with Ms. Cashman or any prior. So this would be a milestone, an epic milestone for me to be able to finally do that. So now if I don't have what I need or I'm looking for, how do I go about, I know you all can't tell me because of legal matters, but do I need to write a motion? I don't know what I need to do in order to finally get a copy mirror download of my phone. If it could be brought to you for physical, but the other physical.
So again, that is going to be something that requires an expert. And then if we get a defense expert, and the JAC pays for it, then we make arrangements to meet with that expert. That expert will have the opportunity to image your entire phone just as we did, and you all can work with that image. And you're going to be, if you don't already, on those thumb drives that Mr. Lane has, if you don't already have the full extraction and not just the PDF timeline of your phone, we're going to make sure that that is provided.
Okay, so that is not able to be included in the other physical evidence that you will find?
No, what I'm saying is there's two different ways that I see phone extractions. One is the PDF, which is what I think you're referring to as the timeline of this communication, so on and so forth. And then there is the actual ginormous file that is read with a UFED program, and all that should be provided to you. Hopefully your laptop can use it. It does take some specifications on the computer to open it. In fact, we're addressing those issues at our office with our own computers. And if it doesn't work, we will cross those bridges as we get there. And I've worked with Mr. Lane before, just let him know. Mr. Lane knows how to find me. We will work this all out and get what you need.
Absolutely, yes. I am grateful for your information. Just to clarify, please, during the physical evidence and me viewing that here in the courtroom, am I not able to physically open my phone and search through it?
No, because
Okay.
it needs to be in a Faraday box where radio signals don't come and go, because anytime you turn on your phone, it changes the contents of the phone.
Thank you
You're
very
welcome.
much.
Ma'am, do you have any other questions?
Okay, so everyone is aware that I'm in the process of trying to talk to the captain. And handcuffs. Okay. Your Honor,
Yes, ma'am.
I believe I am okay for right now. You and I do not have a direct way of communication, and I didn't know. Another big hurdle is if the laptop has internet access, where I don't know if emailing or messaging or whatever, however it is that you and I can communicate, rather than snail mail by me writing a letter. I don't know when I write a letter how soon you receive it, because sometimes it's days or weeks that it is uploaded to the clerk's website. Do you have a general time frame of when you actually know of something? Because you already had my address correction, but I don't believe updated.
It's been updated now.
No, I mean on the clerk's website.
I can't speak to what's on the clerk's website. I know for the purposes of my records and getting information to you, that clerical error has been remedied.
Do you have any other suggestions? If I do not have internet, would my only possibility to correspond with you be via mail?
That's my understanding. And you asked when I receive things. I get it as soon as I get it from in the mailbox. So we check the mailbox every day. As soon as I get it, it doesn't go to the clerk, it goes directly to me. And I review it. As you saw with the motions that you made reference to at our last hearing, that you had 5 of them, we set those for hearing immediately. And I intend on continuing to try to do that to facilitate prompt resolution to any concerns or issues or motions that you may have.
Thank you. And if I do have internet access or am able to put on, if it's not already, am I able to correspond with you via email?
You cannot correspond with me directly, but you can have conversations with my judicial assistant to the extent that you do have access to internet. I'll make sure to include her email address and telephone number in the order setting the deadlines that we addressed this morning.
Yes, thank you. And for any, I'm not sure specifically which JA, but as soon as something is scheduled, could you all please make sure that I'm included in the certificate of service or portal or whatever it is that I might be attached to in order to receive notices to be covered in here?
Notices have been sent, ma'am. To the extent that there was a clerical issue, that's been remedied, but you have been copied on everything that's been filed with the court, including the JAC's response, the notice of the hearing that was set for today, and the notice of the filing of the protocol. With that, I will see you all this coming Friday at 8:45 to address the motion regarding reasonable freedom in movement. State, anything else?
No, Your Honor.
All right, we'll see you all Friday. Thank you very much.
Thank you very much.
We'll return.
Mic is muted. I said, first of all, sleeping cat. So I wanted to make sure that I wasn't misremembering. So I took the last hearing we listened to, put it into ChatGPT, asked it to summarize, and then asked it some questions. So this is the key points from the transcript. Miss Boone is representing herself in the case. Billy Lane, owner-in-chief, chief investigator of Prison Break Investigations, is present to assist with the digitization of discovery documents. The court is ensuring Miss Boone receives the discovery documents via USB drives to be used on a laptop provided by the jail. Judge details the procedures. Miss Boone expresses confusion and frustration about not being properly notified of the hearing and her inability to receive hard copies of the discovery documents. As we heard in the beginning, she also wasn't properly notified this time, it seems. Judge explains the difficulties in communication and the processes established to provide Miss Boone access to the necessary information. Miss Boone questions the procedures and timing, including her challenges in preparing for the trial without proper notice and access to the required documents. The court sets a follow-up hearing for August 5th. Okay, so then I said, do they say when the discovery will get to her? The court indicated that the discovery will be copied onto USB drive and provided to Miss Boone on August 5th. So that was my mistake. It was going to the PI on August 1st. Okay. Then it was getting to her August 5th. So that was on time. Then I asked, does the judge speak about correspondence? Yes, the judge discusses correspondence during the hearing. Here are the key points. Miss Boone mentions sending 5 motions to the court. And this was the 22nd of July, I think. And if they had been received, the judge responds that the last correspondence received from Miss Boone was on July 8th, and the recent motions had not yet been received by the court. The judge explains the process for setting the hearing and mentions that the notice was performed the previous night after receiving confirmation from the jail regarding the process. So it was the night before, but she got woken up at 4 o'clock in the morning, had no idea what was going on, no time to prepare. Miss Boone expresses frustration about not being informed of the hearing in advance, noting that she was only notified at 3 a.m. the day of the hearing. The judge acknowledges the difficulty in communication due to Miss Boone's current housing situation. The judge assures Miss Boone that she'll be properly noticed for future hearings and will be included in the certificate of service for any filed motions or notices. Miss Boone asks how she is supposed to communicate with the court, to which the judge reiterates that she can use the avenues she has been utilizing, primarily through letter writing. The judge promises to diligently review her motions once they are received. So if we remove what we've been told so far from not just the hearings, the outside influences, let's remove that. On the 22nd, she's told the judge hasn't gotten anything since July 8th, which is a significant amount of time. She says, if there's such a delay, is there another way? He says, just keep doing what you're doing. Again, she asks then, please let me know when there is a hearing. And again, she's not properly notified. So she asks in this hearing to be notified. When I went online last night looking for this, it was everywhere as another crazy request. So I was anticipating there being something really crazy. I don't think she has really asked for much that wouldn't be a normal thing to ask for in this. She asked for standby counsel. That's pretty normal for a pro se. Whether you choose to be pro se or not, it is pretty normal to ask. She asked to be notified of hearings. That's something that you would need to be notified as. If you're an attorney, you would. She asked what the best way to correspond is to keep things efficient. That's pretty normal. She asked for extra time to review discovery. That happens every single day in court. It was all pretty normal. And instead, it's kind of like, whoa, she's making crazy requests. But maybe did I miss crazy requests? Because I didn't find anything too crazy. I looked it up and gave you the date. I just wanted to be able to ask ChatGPT the questions because she doesn't have internet. I wonder why she can't access the court files like we can, because she hasn't got internet. She asked for internet. They said, we'll see. So the problem with communication lies within the jail's policy and not the court. I fully understand that. I'm not saying that the court is at the wrong, but a reasonable person would bring it up again if and be frustrated bringing it up again if it was already asked last time and already was told that it would be rectified. So I can understand her frustration. And this is what I was saying. As a journalist, I genuinely feel like she is in a trial by media. I would guess her reason for asking them not to be there is because she can't give interviews to refute things, aka make her defense to the media and gripe about all the perjury by attorneys. But now let's think about it. We only have one side of the story. We don't have her side. And already there's been so many people in chat saying she's guilty, she's awful, how could she do this? She hasn't been able to give her side. We don't know her side. She is legally innocent. And the way that everything is shaped changes that. So I think the crazy is more because of how she's asking. I found her respectful. I didn't find her disrespectful. I actually found that she was very calm. If I was facing these repeated problems and being told, like, just send the mail, and then the next thing, like, okay, but did you receive the mail? No, I haven't, but just keep sending. I had a fight with Google over this for my YouTube stuff. I told them, like, the post office doesn't work in South Africa. You can't send it this way. And they said, okay, well, we'll have to exhaust that 4 times before we can try another option. And I got so frustrated, and the stakes are low for me. But I don't know. I just think that everything is relative to how you frame it and how you see it and what lens you're looking through. I think if you're looking at it through the lens of, like, she's so crazy, then sure, it might look crazy. But if you look at it through the lens of, we don't know, and if she was so crazy, why did no one get a psych evaluation yet? If she is as mentally unstable as she is made out to be, then it still puts the court system in the wrong for letting her go this long without getting evaluated. She's clearly not that level of crazy. Like, there's... Oh, Frank. There's multiple ways to look at the same argument. And that's all I wanted to point out. I don't really, like, I'm pretty removed. I did a lot of research when it happened at first, wrote about it, etc. But the main thing that riles me up is just how it's packaged and how I even feel uncomfortable saying that she's innocent when she is innocent until proven otherwise, or unless proven otherwise, depending on what state you're in. But Lil Miss, she has to quote case law, because that's legally what she's supposed to do. So she's actually doing pretty well on that point, because like if you think back to the Christine Ritchie trial, they had an entire 3-hour hearing reading out case law. So I think it's like, either she needs to be completely incompetent, either people can be frustrated that she's crazed and not making sense, or acknowledge that she's doing what a lawyer would do, but like, where's the in between? She or an attorney has to assert insanity. It's not on the court. So, okay, but then even then, right? Then there's been 8 attorneys. Not one of them has gone, this woman needs to be checked to see if she's crazy. Like, that's weird to me. Also, I have dancing in an hour. So I don't know. Perhaps we put on a little bit of Fleischer from, because he's off. Perhaps we put on Fleischer, and then we can watch a little bit of the Hutch jewelry thing later if all goes according to plan. Gosh, looks like we literally watched everything except this one. I think maybe because I was such an unpleasant drinker, and I didn't drink daily. I was a binge drinker. Maybe because I was so unpleasant, I was a completely different person. And drunk Vicky was just, I would hear things that drunk Vicky did, and I'd be like, that is not me. I would never in a million years, ever. And I don't know. How did I lose this? Okay. Don't close that one. That's the wrong one.
DWI and FSGI. I have his application and I have his personal letter, his character reference letters. I am missing a third letter. He only speaks Spanish, and so his people who are writing him letters.
He was supposed to have everything done by today.
I understand. We're missing one letter.
Okay, I'm gonna roll him to tomorrow, and I'm gonna roll him day for day until he gets it done. If he wants it, he does. If he's got until, I guess, the end of the week, if he doesn't have it done, then I'm sending him for trial.
Understood.
I mean, how many times do we have to keep going at it?
I understand, Judge. There should also be a blood discovery order that was filed on this case. I could please have it signed.
Yeah, I'll sign it for you.
Okay.
But has he done his HERAS yet?
He has not done a T-Rex. Could he do a walk-in without having been accepted?
Is he here today?
He is.
Okay. Keep it on for tomorrow.
Yeah, he's got to come back with everything tomorrow. If he doesn't, he'll be coming back Friday and then every day thereafter. Hey, good morning. Oh, yay.
And Jerry, from the gentleman.
Yes,
I already
please.
gave Ms. Jamesy.
Okay.
You already got that, but I-
Okay,
And so you're.
so you
ready
actually, you got,
Here we go.
hold on.
I told him I'll come back.
Good,
Uh,
okay.
You're ready for?
Yeah, let's start doing arraignments.
All right. Mr.
Yeah, hi, Jason.
On
Hey, Joe, how are you?
the first one, Coffer. Mr. Coffer, come on up, please. Where is he? Yeah, he's on page 8.
Not so offer good.
Coffer. You see it?
Yeah, we don't have it listed as an arraignment though. I got it.
I have it 9 days old. We set it for bond forfeiture because he said he didn't have a ride last time. So that's why we set it for today. If you can just go ahead and read it for me though, or maybe not. Let me see. The magistrate put conditions on him. I wonder why. All right, Mr. Coffer, we're gonna do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Do you have it in front of you? Okay, can you just go ahead and read it, please?
On July 23rd, 2024, officers conducted a traffic stop on a vehicle without a front license plate and illegal front tinted windows. Officers ID'd the driver by his Texas driver's license, and the defendant was observed to have a strong smell of marijuana. Defendant was the back passenger. 0.327 ounces of marijuana was located in a jar within the wingspan of defendant and the driver, and 1 gram was in the defendant's pocket wrapped in a bag.
So who's the driver? And did they get arrested for anything?
Yes, sure. He was on docket yesterday.
Who was it?
Mr. Maria.
Okay. Say it again.
Same charge.
Mr. Coffer, I'm gonna find that there's probable cause to go forward with your case. What do you do for a living, sir?
I'm not working right now.
When is the last time you've had a full-time job?
3 months ago, I work at Golden City.
At where?
Golden City.
Doing what?
Golden City.
Okay. What are you doing now? How do you support yourself now?
I'm just living with my aunt right now. I don't have a job right now at the moment.
Why not?
I'm looking for a little bit right now, trying to find a
Did you graduate from high school?
I got a GED.
Okay, so you have a GED.
Yes, sir.
All right, I'm making it a condition of your bond that you start working.
Yes, sir.
You need to get a job.
Yes, sir.
Do you understand? I will give you an application today for an appointed lawyer. I'm gonna bring you back in 2 weeks. I want to see what you have done to get a job. If you've done nothing, life's not gonna go well for you, Mr. Coffer. Do you understand? All right.
Take an affidavit with me. I'll bring.
No, let's get, no, why? Right, he ain't got a job now, so let's get him a lawyer now. But you will be expected to get a job, Mr. Coffer.
I did ask what I was going through.
I'm not gonna talk to you about the case.
Come on over this way. She'll have you sign for the reset. When she has you sign the proof of reset, you'll just have a seat in the jury box and fill this out, raise your hand, finish. All right. Our next one is Miss Davis on page 11.
Spavel. So We have her on a tampering with government record.
Who's this?
This is, Davis is the last name. Don't say anything, please. Shakara Davis.
Okay.
And looks like she had court on 5/24, but she may have missed court because she picked up an aggravated assault on the 21st. Do you know whether she was still in custody at the time that we had court?
On 5/24, Judge?
Yeah, and then if you can tell me about the ag assault, please.
So I'm showing Judge, she was booked on May 20th and released May 23rd.
Okay, so it's a good bond forfeiture then.
And then she subsequently was booked on June 3rd and released June 6th. So it doesn't appear she was in our custody May 24th.
Okay, so can you give me a heads up about the ag assault, please?
Sure, yes, Judge. The ag assault, officers were dispatched to a disturbance involving weapons. Complainant and defendant are in a dating relationship. Argument ensued when the complainant returned to the apartment and saw another man's clothing. Complainant locked himself in the bathroom. The defendant somehow opened the door, and the defendant was holding a knife in her hand. Defendant launched at him with the knife, and the defendant did hit him once with the knife on his left shoulder. Complainant's cell phone video captures the defendant with the knife lunging at the complainant.
Ms. Davis, do not pick up any new cases. Behave yourself. Otherwise, I will deem you a public danger. I'm going to make your bond extremely high. As it stands now, there's an affidavit for you not to drive. Do not drive. Do you understand? What are you doing with yourselves? Are you working? Do you?
Not at the moment, but I'm looking for work right now.
How do you support?
Yesterday on the case, aggravated case. I just came from court yesterday.
How do you support yourself now?
Right now, I'm actually trying to look for me a patient from home. So.
Right. Did you want to apply for an appointed lawyer, ma'am? Oh, actually, we have a lawyer on her now. Actually, Mr. Yeah, right. Okay, so let's do this. I'm just gonna have you take a seat in the jury box while we wait for your lawyer to get here. Don't violate these conditions, ma'am. All right? Okay, so Billy, let's have her sign a reset now, and then we'll just have her wait for Mr. Foreman to come. Okay, ma'am, please.
Our next one will be Ms. Gonzalez on page 16. Ms. Gonzalez.
Are you Crystal Lynn? Is it Crystal Lynn or Jennifer Gonzalez? You Crystal Lynn Gonzalez? Okay, ma'am, you're charged with driving while intoxicated. You're facing up to a year in jail and or a $4,000 fine because of the high blow. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews with the state of Texas. If you cannot afford a lawyer will be appointed to represent you, ma'am. Okay, Jason.
July 27th, 2024, officers arrived on scene and observed two vehicles that have been involved in an accident. A witness stated that she had been stopped at the light when she had been struck by the defendant's car. The witness stated she saw the defendant to be the driver of the car that struck her. The defendant stated that she had been downtown and was on her way home. She admitted to having one beer. Standard field sobriety tests were conducted, 6/6 on the HGN, 7/8 on the walk and turn, and 3 of 4 on the one leg stand. DIC read and levels revealed 0.175 and 0.181.
Okay. Any prior DWIs?
No, Judge.
Ms. Gonzalez, I'm going to find that there's probable cause to go forward with your case. You have a valid Texas driver license.
Yes, sir.
Do you have valid liability insurance in your name?
Not in my name.
Then you're not allowed to drive. I am making that a condition of your bond. If I find that you drive, I will have a contempt hearing. You'll be facing an additional 6 months and a $500 fine every time you drive. You'll be signing an affidavit that you are not to drive until you have liability insurance in your name and you come get court approval.
Can I ask a question about that? I do drive for my job. The truck that I drive is like a company truck. do I need to get liability insurance on that truck in my name?
You have to have insurance for any car that you drive. I don't care if it's a company car, if it's a personal car, you always have to be insured in the event of an accident, because now they're going to come after you for the damages, especially in this case. For $30 a month, perhaps $50 a month, an insurance company will cover you in the event of an accident, and you have lawyers that will represent you. That's why it's so important. I'm only asking you to follow the law. As it stands now, if I find that you drive in violation of this, I will put you in jail. I'll make your bond extremely high.
Okay, so as long as I have liability insurance on the truck I drive, I can.
Sure, it has to be a policy with your name on it, with the car that you're driving. And we have to be able to see it so we can verify that. Do you understand? All right. I'm also ordering you as a condition of your bond not to consume alcohol or illegal drugs. I'm going to randomly test you. If I find that you're consuming alcohol or any kind of dope, likewise, you will go to jail. So what do you do for a living?
Pool maintenance, like a residential commercial pool.
Okay. And how much money do you make a month?
About 3,800.
Okay, so we're going to reset your case to give you time to hire a lawyer. It would behoove you to do it as quick as possible. There's a lot of timing requirements with the DWI.
I did already hire a lawyer.
You have a lawyer?
Yes, sir.
Who is it?
I spoke with someone named Jeff Casey, but it's Durham and Jones long term.
Have you given them any money?
I have not paid them yet.
Then you don't have a lawyer. They don't work for free. You need to hire them.
Yeah, I had a payment agreement.
So look, all I'm going to say for now, we're going to reset your case. We're going to give you 30 days. Don't wait 30 days because you're only hurting yourself. Just get on it quick. Do you understand? All right. So for now, I'm going to have you come up here, swear to us that you're not going to drive without liability insurance. And then I'm going to get you to Billy. We're going to have you sign a reset. And then eventually you're going to get with Tracy for your bond conditions. And after that, you'll be free to go.
Go ahead. Go ahead. Come on. Piece of paper for you to sign.
Oh, it's locked.
Sorry, I was busy quickly editing the Judge Simpson thing. It went completely different to how I anticipated, and I really want to get it up on YouTube before I leave for dancing, but that's in 15 minutes, and I don't think I can. But I want you guys to see it so badly. And I want you to see beginning to end because it went completely different, completely. Wait, I'm just going to skip to a random spot. There's a little one. Oh, why is there a little one?
Really?
It was, yes. My husband's from home. The zipper was in.
Hey, who got appointed to represent Herndon? Really? Again?
That's what I think because old cases. And she's.
Yeah, but she's not in here.
I know, that's why that's why.
Yeah, let me.
Because I know that's what she went to, some of that cases in the, I think the old cases still active. This is what happened there.
Okay.
Well, that's what. You get to sit down for a brief moment anyway.
So like 2 weeks prior to, just come back and we can have like an informal, kind of 2801 or just, get with Pavel for like any kind of redactions, see what you can agree on.
Okay.
Also with motion, in limines and all that. And then whatever you can't agree on, come back and let me know.
Okay, so you want to set on a normal date?
No, you don't have to. Just come back and inform me. This is what you do. See?
Who's stolen? Friends that were there, is that his little one?
Are you gonna color? My pen? Feeling?
Oh,
You
it's the
feeling
sicky
okay?
one.
What's the start?
All the commissioners documents true quick there.
It's a 2, that's right. So Philly, with Herndon, with the original case, all we had left.
Don't worry, Dream Crazy. The judge actually pops in here, and he's totally chill with it. Doesn't mind me streaming. I'm a mod on his channel, so it's okay.
To do with sentence him.
Correct, Judge.
Um,
So I requested for the new case and the Mac attached case.
right, but like she's done essentially. So, and she's not even working in here. So can we get someone else so that she doesn't have to come all the way back over here? And then I guess I can. No, I haven't. No. It turned on.
It's still here.
Yeah, I haven't sent. I don't think I've sent it.
Still pending.
Okay, thank you. Judge, may I approach?
Yes, ma'am.
I'm throwing Crystal Lynn Gonzalez. I just wanted some clarification. It seemed, I was with Mr. Sorrell and I think we were going over conditions. I'm studying it for David. He's out of the office.
Oh, he's signing on? I didn't realize that
Yeah.
she had a lawyer.
Yeah, I just filled out an attorney of record.
Oh, great. Okay, so the only issue I would imagine is the insurance, right? So if you can.
Driver's license, we just checked the DPS eligibility site. She doesn't have a personal vehicle. So the only vehicle that she would be driving is a company vehicle. She just showed me a copy of the policy. They have
Just show me, show me that she's covered and then we'll take it off.
So she's not named on the policy because it is a company.
So she's not covered.
But she's not, but no one is, like, no one's listed as like an insured, if that makes sense.
No,
I think that
it doesn't
anyone
make
would be
sense
driving-
because insurance company cover a person, right? Not just a vehicle because,
I can show you the policy, what it looks
sure, I'll take a
like.
look.
It doesn't have any people named on it.
And especially now that she has a DWI, does the employer know that she has a DWI? Huh? Right, I'm not gonna do it unless I know that if she's driving a company car, she has a DWI, no one knows. Until I know that the employer knows and that they still want her to drive with an open DWI, a company car.
It's before that 150. There's like 4 vehicles, I believe.
Hold on.
Yeah.
Do you want to go back to the room back there, or do you want to stay up here? What do you want to do?
I wanna go.
Lori's kind of a snack.
Is it open back there?
Yeah, I left it cracked, so some of it is still there.
Oh, it's the judge's own YouTube channel.
If you can show me that they know and that she's covered, especially with the DWI, then I'll take it off. But I mean, I can't imagine that that's policy will cover her, especially in light that she has a DWI, an open DWI on a company vehicle. That's not.
I mean, she doesn't have a vehicle before the DWI, so I would assume.
That doesn't make it right, though.
I would assume she's on this covered, especially since
Well,
no one is.
Okay.
Since it's a company.
With an open DWI, I'm not going to do anything on assumptions. Just let me know, like, let them know, and if they're okay with it, and that they can put it on the policy so that she's named on it, then I'm okay with it.
Yeah, Judge, those commercial auto policies need the driver listed.
Right, I mean, it's, you have to have a named policy. I mean, that's what insurance companies.
When it's a company vehicle, when I ran companies, I only cover anyone.
So you're telling me that insurance company is going to cover it with an open DWI?
Well, no, the company is going to be responsible for that. Could they put the company? Like when I was going directly, and I got my car insurance on fleet vehicles. It covered the whole company, anyone that the company designated as a driver.
Yeah, it would be listed as a driver.
Judge, that's my impression. I used to do so.
Show me, as long as they know, then I'll be okay with it. But I want to know that they know that she has.
Because yeah, I'm pretty sure it's like blanket, like anyone who's driving the company vehicle would cover that at a time. She was driving like this even before this wasn't even an issue. But I'll see what I can do.
Okay. You're back?
I'm back. I'm here today.
Did you get everything done? that you wanted to do?
I have some stuff to start with you later, but I'll
That's
wait
okay.
till it comes out. Okay, so you just appointed, the county
Oh, yeah, right.
Mendoza. I think him right now, like what he hasn't done and everything.
Is it on docket?
I guess
Yes.
so.
Or
No, it's not. It's
Have not, no, I haven't signed it yet
Might have to give
because I brought him
number.
today. I'll probably do it today.
245-1592.
And then I have an acknowledgement, work, it was a status update. He's completed his IOP. And the SOP class. And I talked to the providers and he's doing good and everything there. He doesn't complete the SOP until September 13th. You want to bring him back up?
Let me see, let me do this
One thing
first.
at a
Yeah,
time.
one thing at a time. Let me, Mr. Mendoza, come up. Thanks for helping. You're up.
Okay, I thought it was anyone.
No, 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 no.
Okay.
All right. So, Mr. Mendoza,
Yes, sir.
I brought you up
Yes, sir.
because you have been on probation since September of, I think it's September of last year. Am I right? Or August? August 7th. When you're on probation, you're to do several things.
Yes, sir.
And you're supposed to do them based on time.
Yes, sir.
And when you don't, there are consequences. You haven't done, but I think one thing. Have you spoken?
I have spoken to him, Your Honor. I have not seen the motion.
Because I'm about to file it right now. That's why.
I have spoken to him, Your Honor. He has gone through a lot of financial difficulties. I understand that's not.
Mr. Eddie Mendoza. I am now signing a motion to revoke your probation. And I'm taking you into custody. He goes with you. And then we can talk about whether he wants to stay on or not. There will be some sort of, punishment, so to speak, for his failure to do anything. If he wants to stay on, he can. If not, then we will talk about how to resolve it another way, I guess. He goes with you.
Okay. I was trying my absolute best to get this video exported and everything. It is really good. And I spent hours over the weekend. I want to say like at least 7 or 8 going through, finding like every single possible hearing, putting the things together, looking into things. And it still says it's got 14 minutes to export, but then it still has to upload on YouTube and go through checks and all of that. So I'll have to show you guys later. I might be able to come back in the evening, but I'm not sure. Just make sure your notifications are on, because that is going to be the best way. Unfortunately, mine don't always work. Can't get my shoe on. Anyway, thanks for hanging out so far. I forgot that I didn't change the thumbnail yet. I'll have to make a note to do that as well when I get back. Because people are going to be very confused. Just please don't go watch the most recent Judge Simpson, because I want you to see beginning to end. It doesn't make sense if you don't see all the parts. Okay. See you guys later or tomorrow. Thank you for hanging out with me, and everyone who is new, I'm so glad you found me. I'm generally live at around the same time every day, which is 1 p.m. Central African time, or roughly 7:30 Central Time US, somewhere around there. I will see you guys soon. Bye.